throw something at the TV. That would be me. All right. Not to bore you with the details, but 2 days ago, I installed Brave Browser. So I'm kind of thinking, well, and then, like I said, my fellow suburban Erin in the chat said she had problems with the internet the other day here in the south burbs, I should say, of the Twin Cities. So as I was running down 2 flights of stairs and running back up here 2 flights of stairs to hard reset the modem, router, whatever it is called, it kind of dawned on me, this whole Brave thing. So I must have some kind of firewall set up because it's so weird. Like, it's connected. I'm not dropping frames, but then I get the spins. So without having to bore you with all of those details, we are back again. Now I have to find the spot. Sigh, and more sighs. Your patience is appreciated. This is episode 7, B, as in buy me a drink. All right, let's just find where we were.
Again, I identified blood on those swabs.
And I'm just listening to see. I should have wrote it down.
Yes.
That would make too much sense.
Whose DNA was that, if anyone's, in terms of a match?
The profile, again, I compared to the profiles from different individuals. Again, all were exclusions except one matched, and that was from Rosalio Gutierrez.
So I'm going to ask you finally then to take a look at State's Exhibit 88 and ask you in terms of packaging, is this packaging consistent with item BA, the sample you just talked about and sold?
Yes, it is. It has our laboratory case number, that designation letter, BA, and I, again, have written my initials and the date on the packaging.
So I've showed you a number of packagings. Mr. Witucky, are you able, what if anything can you say about whether you're confident those packages are the same? I mean, you haven't opened any of them. So are you confident that those packages are the same items that you conducted the tests on that we are talking about, and why? Without opening them, how do you know that?
Well, first of all, when we look at an item of evidence, the laboratory case number with the item designation letter.
So, those of you who are coming back in, thank you so much for the kerfuffle, if you will. Sometimes Mark has popped in here. He's my sister's longtime boyfriend. He's the one that so generously gave me this Screaming Demon. Don't let me even start down the path of how wonderful he is. He used to work for C.H. Robinson as like their #1 computer guy team. So this guy knows computers. And he gave me this just beautiful thing, but it's got to be, it must have been something in the Brave browser that's like I don't know, like some firewall or something that I can't have closed. I don't know. I don't understand, but we're good now, so I'm going to shut up so we can figure out where we were.
Label is placed on that package, and immediately when I take control of the package, I place my initials with a pen and the date that I
feel
took
like a
control
fool,
of
I
it.
tell you, a fool.
And then when my testing is complete, I repackage the item, reseal it, and
I'm pretty sure we were past this. Yes, we were. We were past this.
The is human tissue, but we were not able to do any testing to determine.
Weren't we like at the part where the defense was starting to take over?
You don't want
roughly?
to lose up all of your
Word.
By her at the crime line.
And again, that is not
DNA. When you
Of a decision made based.
I'm just going to pause for a moment. Can you tell me if this is where we were, like roughly? I'm kind of frustrated and winded, frankly. And let's be real, I live like on a house that has like a forest behind me and a lake. And then across that way, it's like forest. So I'm like in a forest sandwich here. And the basement is finished. It's actually probably the best level of the whole entire house. But I found a mouse downstairs, which is common. We get, you know, I don't know how they come in. I actually think they kind of crawl up in like the, what do you call that? The sump pump tube that goes out the back. And let's just say this little creature was caught, you know, because I set traps in the basement. Let me just tell you my mouse story while everybody comes back in here. It's a beauty. So I always set these mouse traps in the winter in the garage, hoping to catch them before they come in. Because I think there's also like a hole underneath like the stairs that go from the garage to the mudroom. And then into the utility room. There's got to be a gap there somewhere. I don't know. Let's just say I went downstairs to check the mouse trap, as I do every day, because, you know, if there's one, there's a lot of them. And the mouse trap wasn't there. I thought, that's weird. So I looked around. You know, sometimes when the mouse gets caught in the trap, they're called jaws. The mousetrap jaws. It's a thing of beauty, let me tell you. And sometimes when they get caught, depending on, you know, what have you, the trap will kind of like flip upside down and scooch a little bit. So I'm like looking behind the bookshelf. I'm like, oh, that's really weird. So I went down this, you know, like little hallway thing, and there was a box that had some books in it that I was, you know, because for those of you who know, I'm probably going to try to sell the house next year and move somewhere warmer and with, you know, I don't know, warmer. Let's just put it that way. And there's this box that has books in it, and it had like little, you know, like little handles to like hold the box up. And the mouse must have like got his whisker caught in the trap and ran away. So just like his little whisker, he was dead. So now I'm kind of afraid when I go down there. I'm not going to lie, that was really weird. Normally it's just like smush, there they are. Oh, go get the gloves. Fill up the tray with Nutella. P.S. For those of you who have mouse issues, they are addicted to Nutella. There, now you know all my secrets. Well, not all of them. One secret. One day at a time. That was really freaky. I'm like, oh, where is it? You see the little mouse trying to get back into the box, but he can't because his whisker's stuck. All right, here we go. Well, we're just going to start here.
On any factor, not
oh my
to
God,
conduct
and
any
if
chemical
this
testing to determine whether the item
goes
that they
10
identified was blood.
10 toes
Were
up
you aware
again, I don't know. I'm going to just
that
cry.
decision was being made by the crime
Go in
lab
a corner.
in this case?
I was aware of that decision, and I would say that any crime lab in the country would have probably taken the same path.
Okay, I'm so sorry. I do have another mouse story. C-Swept said, if mice could peacefully cohabitate like in Walt Disney films, but no, they have to beat you and chew and go to the bathroom everywhere. Okay, so that's another interesting story. So the triplets, so where we live, the elementary school is like walking distance, and the high school, they say, is walking distance. Their walking distance is 2 miles. I don't know if you've ever walked to and from somewhere in the wintertime for 2 miles. Plus, on top of it, it's like a very busy intersection that they would have to cross. So that's a whole different issue. But the middle school is far enough away where the kids had to take the bus. And middle school is 6th, 7th, and 8th grade here. So one day they were coming home from school, and I would always wait with, some sort of snack because they always come home starving. And they walk in the door and all three girls are crying. And, sometimes I would wait in the car, for them to come back because you'd have to walk all the way to the mailbox. Doesn't matter. But this wasn't cold enough where, they needed a, ride home. They come in the door, they're crying, and I'm pretty sure they had a box or some sort of shoebox, or I don't even know where they got that. But they had found a mostly dead mouse on their little walk home from the mailboxes. And they're crying, "Mom, it's almost dead." And I'm like, oh my. So we brought him indoors, and I think Willis was still alive. We've had a couple hamsters, and so I fashioned some type of like little clear box thing with tape and holes and, hamster bedding in it and water and food. And, we put the mostly dead mouse in there, and we named him Stuart. Now, there's another thing with that, because remember when Wii's were really popular and you could make your me, the Wii game thing? Well, one of our nannies, Jenna, I came home and the kids are playing the Wii, and she had named one of the Wii Me's Stuart. Sthewart, like Stuart with a lisp. Let's just say Stuart kind of looked like this guy here. Well, so we named him Stuart, and from the movie Stuart Little. And okay, so that was the mouse story. Well, then, like, I don't know, a couple days later, he was like, or she was doing just fine, like looking at us and whatever. So they thought, well, let's test its social skills, or I don't know what they were trying to do. And I'm like, all right, well, if you're going to take the, Stuart out of the box, you're going to have to, put towels underneath the door. And I don't really think it's a really good idea, and so I said, I don't really want to be here because the tails kind of freak me out a little bit. And so I shut the door. I'm like, all right, girls, well, let me know how it goes. And not even like I had shut the door and took 3 steps and they're screaming, "Mom!" Well, apparently Stuart was like, he turned into Speedy Gonzales. Somehow or another, they caught him and they quickly ran across the street and set him free. They didn't want nothing to do with Stuart anymore. So there's my story. I have more stories. I'm not going to keep boring you with them, though.
That when you have such a small amount of material to work with, you don't want to risk losing the DNA evidence to
I have so many funny stories.
Tests that may use up all the sample or a good portion of it, that you don't get a result or a DNA result later on.
Involved in your peer review process, were you reviewing the judgment by Ms. Treffinger that the item identified on the van as A1 appeared to her to, by visual observation, be consistent?
I'm going to object. That is not an opinion in her report.
I indicated her overall assessment. If he peer reviewed,
I didn't hear you.
If he peer reviewed her opinion that upon visual observation this item A1 was blood. Did he peer review that?
What?
Excuse me.
Item A1 was what?
Was blood. Did he peer review that particular opinion offered by her or conclusion offered by her at the crime
And again, that is not an opinion, that is not an opinion or conclusion that was included in her reports or any findings that I could note other than her testimony in this court. So I don't believe this analyst could have peer-reviewed an opinion or a finding that was not documented.
Well, I believe he has.
Let him
Oh, wait,
answer and then
we were past this, weren't we, with the
So,
peer-reviewed
do you
thing?
Is not a very good source of DNA.
God dang it, I wish I
And
would have,
while there wasn't a lot of DNA in this sample,
we were past this too. I'm so sorry.
that's
Please
a fair
forgive me.
statement. Lisa did magnify it for me, so
I think
I was able to observe,
I think we're a little warmer.
the edges and the overall surface texture. But you're right, there are limitations to viewing a photograph.
Some of those limitations have to deal with the angle that the photo was taken at, things of that nature.
Yes.
I want to go back to the State's Exhibit 44. Is that still, did the state hand that to you? It was your report?
I did. Yeah, it should be
Okay.
there.
So you had testified about some swab that you had extracted for testing, correct, as it relates to a pair of jeans?
Yep.
And you
Correct.
you had known that those jeans belonged to Mr. Anderson.
That's what I was told, yes.
And you were told that by whom?
I believe it was on the inventory sheet as to who they belong to.
And on the inventory sheet, it tells you, hey, this is really a very casual way of putting it, but hey, can you see if you can find, these are the interested parties, this is the suspect, this is the victim, can you see if their DNA is present anywhere?
Well, correct. I mean, I was told to examine the item, see if I could find any stains on the item, and if so, make comparisons to any known individual profiles to see if it matched.
Okay, so as far as Mr. Anderson's jeans, if you could just turn to page 2 of 5 of Exhibit 44 of your report.
Okay.
So under item says cutting of left cuff area of jeans, item AU2, that whole portion.
Okay.
And that was you had talked about it at length on direct with the state, but that was the sample that had resulted in a 2-person mixture, correct?
Correct.
And so you did what's called an STR mix to determine if you could make a conclusion of the mixture.
Correct.
Can you explain what that is to the jury?
So in this situation, I found a mixture that was consistent with 2 individuals. Now, I ran the SDR mix computer program on that sample. And part of the procedure is if you have a profile developed from an item where it's likely that you know one of the contributors, then you need to tell the program that assume that this profile from this individual is present and tell me who the second person is in the profile. So that's basically what this profile did. And then when I compared the known individual profiles to this second contributor, each one of them came back as an exclusion that they could not explain as being the source of that second contributor.
And so one of those mix that you put in for this comparison and analysis was the DNA profile of Mr. Anderson and the DNA profile of Mr. Gutierrez, correct?
Correct.
And when you ran that test, the results came back, the likelihood ratio was 0.
Yes, and that means there's no, it's an exclusion, and the evidence is not explained by a mixture of those 2 individuals. So that person is excluded as being the second contributor.
And exclusion with a 0 likelihood ratio means it's absolutely impossible that none of that person's DNA was on that item.
That's correct.
No further questions for this witness.
No questions on those.
You may sit down, sir.
Let's just, for those in the back, let's just rewind that part a minute. I should probably snip it.
Ratio means it's
Not explained by a mixture of those two individuals. So that person is
Thanks for
excluded
coming
as being
back,
the
Log
second
Kong
contributor.
Express.
and exclusion with a 0
0 times
likelihood
0.
ratio means it's absolutely impossible that none of that person's DNA was on that item.
That's correct.
That's correct. Impossible.
No further questions for this witness.
No questions on those.
You may sit down, sir.
Yet, up until this point, midway through day 7, look at this man. Look at this man. For 7 days of trial, they have alluded to the fact, pointed, in fact. Oh, Steve Hammer, if you're watching. Well, it's too late now,
Are
but we
you,
do like to take that
folks comfortable?
time to pause
Now,
for a moment and reflect that Zachariah Anderson has now been incarcerated for 1,319 days. 3 years, 7 months, and change. 7.5 approaching-ish. We are having a side conversation about the movie Princess Bride in the chat. For those of you who have not watched Princess Bride, specifically those of you, I find it a high percentage of men I ask if you've seen Princess Bride. No, I've never seen that movie with like a little, scrunch of the nose. I'm like, what? What do you mean you haven't seen Princess Bride? There's sword fights. There's pirates. There's rodents of unusual size. Or sometimes to really confuse them, I'm like, there's ROUSS's. Okay, and but somebody said inconceivable. So if you see Lily in the chat, inconceivable. Okay, so my children watch. I used to have that. Well, I've loved that movie for a very long time. And when the kids were little, I'm like, I wonder if they're old enough to understand Princess Bride yet. And they've loved it. And the girls were still pretty little. I want to say like maybe first grade or something. And Lily, the one that comes in the chat with all the the compulsive heart giver, her and I used to say, when we would say, like, I'd say, I love you, Lily. And she'd say, she'd say, I love you. And I'd say, I love you more. And then she'd say, inconceivable, like when she was 6. So she knows that part. Andre the Giant and what's his face? The guy, the actor with that says inconceivable. I forget their names now. I'm old, forgive. Inconceivable. Every time, oh my gosh, that's another good sound clip. Plus, Lily will even watch it more. I think her and her friends are getting addicted to this tryout. They seem to pop in quite a bit. All right. I will try to keep all of my stories to myself for the remainder of the live stream today.
Been here 8 days. I should ask if they're comfortable.
Oh, and I don't have that chat up yet either. Okay, doesn't matter. Doesn't matter. You're here to watch this.
Please raise your right hand. Do you solemnly swear the testimony you're
Okay,
about to
let's
give in this matter
note
will be the
that
truth, the whole truth,
that the judge
and
has
nothing
in
but the
fact
truth, so help you God.
remembered to swear in
Thank you.
this witness as well. On day 5 or so, he forgot to swear in a couple of them.
Casalina Remsburg, Casalynaremsburg.
I want to turn your attention
Remsburg,
back to the time
pause.
period
Who is this person? Remsburg? The transcripts Okay, Kristine, here's how you can get the transcript. All I do, and I'm not going to demonstrate because I really don't want to have to, you have been so patient. Kristine, all you need to do is go down underneath the video, hit show transcripts. And then you can either leave, I usually take the timestamps off. I've only done this for a couple days. And then you just, hold copy and go all the way down. And then when you're done, when you get to the bottom, hit right click, copy, and then open up your Word document or, alternative Word document and hit paste special. And then it'll just put in the characters. If I have time, I will figure out where I can put it. Twitter will not let me post it in a PDF on my Twitter account like I had suspected I could. So, and since it's so lengthy, if it was like 8 pages or so, I could do screenshots. I don't know where to put the PDF. If that makes sense. So we're going to have to just, if you need it right now, then I would suggest that you do that. I've already kind of distracted enough. So let's just keep watching the trial for now. All right, there.
Mid-May of 2020. Were you employed in May of 2020?
Yes.
And in general, what kind of job were you working?
I was
Kristine's
assistant
sister.
kitchen manager at Quick Trip.
Okay.
I'm gonna
And
be quiet.
were you living with anyone during that period of time, May of 2020?
My older sister, Christine.
Okay, and is her last name Remsburg as well?
Yes.
Okay. And how long had you been living?
Okay, so remember when Kristine testified? So Kristine, at the time of the crime, Kristine was Zachariah Anderson's sister. And when Kristine testified, when Kristine testified, she had, so Zachariah's girlfriend at the time, when she testified a few days ago, she had said that didn't she have some sort of accident, I think? And so her memory wasn't that great. So I'm assuming, yeah, Kristine was Zachariah Anderson's girlfriend. And I am assuming she's going to be testifying because I think Kristine had actually said, you're going to have to ask my sister because I don't have something to do with her memory. She had memory issues. So I'm thinking I could be wrong.
With Christine Remsburg by the time period of May of 2020?
About 2 years at that time.
And in that capacity of knowing Christine Remsburg, is there anyone here in the courtroom you also came to know through her?
Zach.
Okay, is that person that you've just named as Zach here in the courtroom?
Yes.
For purposes of the record, could you point out where that person is located and say what they're wearing today?
He's right there. He's wearing a gray tuxedo.
Indicating the accused.
Okay, and so I'm going to refer to him as the defendant.
Okay.
You'll know who I mean, correct?
Yes.
Okay. So, Ms. Remsburg, during the time period that you were living with, in May of 2020, how did you know the defendant? So, how was he connected to either you or your sister?
He was my sister's boyfriend.
And how long had they been boyfriend and girlfriend to your knowledge?
About a year.
Okay. And that was all a period of time that you also lived with your sister?
Yes.
And during that approximately a year, how many nights, if ever, would you estimate the defendant would spend at your home with Christine Remsburg?
About 4 or 5 nights a week.
And that was through that entire about a year?
Yes, about.
How often did Christine Remsburg go over to the defendant's home during that time period?
She almost never, only once.
Once in their entire relationship?
Yes, that I know of.
Okay. And at the period of time of May of 2020, now I'm directing you now to May 17th through 19th of 2020, right? Just before someone came and found you at Quick Trip.
Okay.
Did you know your sister to be driving a particular vehicle during that time?
Sometimes she would drive Zach's car, which is the black Audi.
Okay. And why was she driving that car, if you know?
She wrecked her old car.
When she wrecked her car, was she, to your knowledge, was she the regular driver of the Audi because her car was wrecked?
Yes, I think so.
Okay. And so what car did you observe the defendant driving during that period of time? So May of 2020.
He usually drove the gray van.
That would be the most common car you would see with him?
Yes.
And now I'm going to turn your attention to May 19th, 2020. Did you work a 2 to 10 shift on that particular evening, if you recall?
Yes.
And on the 19th of May of 2020, did some people come who interrupted your work shift?
Yes, it was 2 detectives.
Okay, and did they appear to be from the Kenosha Police Department? If
Yes.
you know?
Yes, I think so.
Okay, and were they asking you about what had occurred 2 nights earlier on May 17th, 2020?
They asked me if Zach was at the apartment that night, and I said no, he was not.
And you felt confident of that?
Yes.
Now, it had only been 2 nights earlier, right?
Yeah.
So your memory wasn't a problem.
Yeah, correct.
Okay. And do you know on that was a Sunday. So on that Sunday, May 17th, 2020, did you work a shift?
Yes.
So you worked from when to when, if you know?
I worked 2 to 10 that night.
Okay. And then where'd you go next?
I just went home right away.
All right. And when you got home, what, if anything, can you say about whether the defendant was present?
He was not.
And was anyone present?
My sister was.
And what do you recall about how your sister was acting or feeling about the fact that the defendant was not present?
She was a little upset because she was going to make dinner and he wasn't there. So.
All right. And at the time you saw her after 10, did she have any explanation for why the defendant was not present?
Objection calls for hearsay.
Is it being offered to prove the truth of the matter asserted?
Yes.
She's already testified. Ms. Remsburg has already testified. This is her simply indicating what her impression was.
Yeah.
Let's keep it with
Objections overruled.
Okay. So again, did it appear to you that she knew, had she received any information or knowledge of why he wasn't there?
No, I don't think so.
Okay. What time did you go to bed that night?
Probably around midnight.
Other than you and Christine Remsburg and then the defendant 4 or 5 nights a week, was anyone else living in the residence at that time?
No.
Look at that man's face. Someone who has been in prison for
If you know, during this time period of May of
1,319
2020,
days.
were there times when your sister and the defendant would leave and go elsewhere, go out someplace together?
Once in a blue moon, they would. Yeah.
And if you recall, what vehicle would they commonly use? Again, if they used one vehicle commonly, if they both went out somewhere.
I think it was a black Audi.
Okay. I don't have anything else.
The state had asked you about, when your sister and Mr. Anderson were dating, if they would go out on dates, and you said maybe once in a ways, things of that sort.
Yes.
No further questions.
Nothing on that.
You may step down.
Your Honor, state calls Marquand Washington to the stand.
The snitch. This is the snitch. Oh boy. I'm gonna have to unplug my microphone and unplug my mouse so I don't interrupt this. Sean Okay, so, and actually, okay, so I normally don't ask YouTube for assistance, but it would be really handy if there would be a way to get like transcripts of your chat. Because there's so much good information that goes through that.
Testimony you're about to give in this matter will be the
Oh,
truth,
and he
the whole
remembers
truth,
to swear
and
him in.
nothing but
I
the truth. So
promise.
if you got it.
I'm going to just unplug
Please be
it.
seated.
Or put handcuffs on myself.
Mr. Washington, can you
In
state
protest.
your first and your last name and spell your names for the record?
Marquand Washington, Marquan, Washington, Washington.
How old are you today?
31.
And where have you most regularly resided in your life, lived in your life?
Racine, Wisconsin.
Have you ever been convicted of a crime?
Yes.
How many times?
6.
And are you in custody right now for charges that are called federal charges?
Yes, sir.
And does that mean the U.S. government is prosecuting you?
Yes, sir.
So it's not the state of Wisconsin that's doing it?
No, sir.
And pursuant to that federal charge, in general, where are you being housed? Are you in a federal jail or prison, or are you in a state institution?
I'm in a state institution in KCDC, but it's mixed with federal as well.
Okay. And so KCDC is a institution or jail here in Kenosha?
Yes, sir.
Judge, could you ask the witness to talk right into the microphone? Can barely hear him.
Yeah. You got to speak up. Okay. Can you do that?
Yes, sir.
Yeah. Thank you, counsel. As part of your federal prosecution, have you entered into a plea agreement?
Yes, sir.
Okay. So I first want to talk about what your federal charge is. What do you understand you are charged with right now?
Conspiracy.
Okay. And is that to conspiracy to deliver drugs, illegal drugs?
Yes, sir.
And what are the drugs that you are charged with conspiracy to deliver?
Cocaine and marijuana.
And would it be accurate to say that the cocaine that you are charged with conspiracy to deliver is 30 plus kilos of cocaine?
Yes, sir.
Okay. And what quantity of marijuana are they saying that you were in a conspiracy to deliver?
I believe 600 pounds.
Okay. And so you've entered a plea in that case. Is it a plea of guilty?
Not guilty yet, but.
Okay. So what is your status right now in that case?
Witness's last word was but.
I thought you said not guilty yet.
Correct.
Oh, I thought
said yeah.
I thought you said, yeah, you're right, that mic doesn't work.
Yeah. Okay. Should I go on?
Yeah, please.
Okay.
Sorry to interrupt.
So, and is it your plan to enter a plea on those charges?
Yes, sir.
Okay. And have you entered into a plea agreement with the government?
Yes, sir.
And is that a document or agreement you've signed?
Yes, sir.
And does it indicate you are going to plead guilty to some charges?
Yes, sir.
So did you do these offenses that they're charging you with then?
Not the amount, but yes, sir, I have.
Okay. So you're pleading guilty to the charges that we're talking about?
Yes, sir.
All right. Does the plea agreement, what does the plea agreement say about whether, if you know anything about other crimes, whether you should talk about it or testify or any of that? What do you understand your plea agreement to say about that kind of stuff?
The plea agreement basically said that if I was to enter into this plea agreement and sign it, I would have to be honest about anything that I had knowledge about.
Okay. And so you're supposed to be obligated to do that?
Yes, sir.
Okay. And is there a benefit that you believe you would receive if you provide information on different cases?
If I'm honest about everything, possibly yes.
So what do you understand could be your advantage? So like how could you be helped if you're honest about some other crimes?
What do you mean, like?
Well, like what advantage what's in it for you, I guess is what I'm saying.
Well, leniency on sentencing, I guess
Okay.
so.
And do you know what that means? Like what number that means?
No,
Okay. Has anybody told you what the number is?
no.
And what is your understanding of what happens to you and your agreement if you are dishonest to a court or to authorities? What happens to you if you're dishonest?
I probably wouldn't get anything for it.
Okay. Are they able to hold that against you?
Yes.
So could you be worse off if you lie?
Probably so, yes.
Okay. And could you mess up your whole agreement?
Yes, sir.
So, and have you been warned about that? Have people told you, here's what might happen if you make something up or if you lie?
Yes, sir.
So you feel like you understand what the consequences are if you were to tell lies in a courtroom or to authorities about any matter? You think you understand what happens?
Yes, sir.
So how long have you been in a jail in Kenosha on these federal charges? Like, when did you first get to Kenosha for jail on the federal charges?
I believe about 15 months ago.
You remember what month it was or not?
Yeah, December, I think, of 2021.
Okay. So, and at some point during your time in the Kenosha jail system, did you come to be housed with a person who you found to be named Zachariah Anderson?
Yes, sir.
And what did you call that person? Like, when you were speaking to them, what did you call them?
I called him Zach.
Zach? Were you, if you know, did you room with that individual personally? Like, you were actually a roommate of that person's?
Yes, sir.
And which institution? So there's a downtown jail and then there's KCDC, right?
Yes, sir.
Have you been in both of them during this period of time of incarceration or just one?
I started off at downtown area for a week or so, and then I went to KCDC.
Okay. So is the place that you roomed with this person that you said his name Zachariah Anderson, was that downtown or was that out at KCDC?
It was at KCDC.
And when I say that you room with someone at KCDC, tell me what physically that means. Are there 5 or 10 roommates, or just, how many people are, when you say you room with somebody, how many people does that mean?
Just 2 people, me and another person, which was Zach.
Okay. So for a period of time, it was just you and Zach?
Correct.
Okay. And is the person you're identifying as Zach, is that person here in the courtroom today?
Yes, sir.
So could you point that person out today, and Mr. Washington, tell me what that person is wearing today?
Yes, sir.
Please point that person out.
Yes, sir. He was right there in the gray suit with the gray and blue tie.
I'd ask the record to reflect identification of the defendant, Zachariah Anderson.
Pointing at the defendant.
Mr. Washington, did you room with the defendant from a time period from about December 22nd, 2021 through January 31st, 2022? Does that sound correct?
Yes, sir.
So if I calculate correctly, that's approximately 5 weeks, right?
Yes, sir.
Okay. And during that time, did you and the defendant come to know each other?
Yes, sir.
And did you have discussions with the defendant during that period of time?
Yes, sir, we did.
And at some point, did you discuss your case?
Yes, sir, I did.
And at some point, eventually, did the defendant discuss his case?
Yes, sir.
So when you discussed your case, who else was around when you were talking about the details of your case with the defendant?
Just me and Zach.
When the defendant discussed his case, who, if anyone, was around other than you and the defendant?
Just me and Zach.
What, if anything, can you say about during the period of time you were with the defendant, whether you observed any behavior about him having trust issues about people or being paranoid or worried about the government?
He had a lot of paranoia and different trust issues when we was in the cell.
Okay, you got to speak very clearly, okay?
Okay.
So, all right, so what sort of things did you see that caused you to think, okay, this guy is thinking the government is doing stuff?
Oh, when I was in the cell, he would, initially stated that it was a couple of times that he thought maybe that the government was putting informants in the cell with him, or maybe bugging the cell or recording things without his knowledge.
And did you ever see him do any searches?
Yes.
And what did he tell you, or what did he indicate to you he was searching for?
He was checking to see if there was any recording devices around or some type of camera or some event, just looking.
And did he ever discover anything?
No.
And what, if anything, can you say about whether the defendant, what his opinion was of his own intelligence, or about an ability to be outsmart people?
Well, he thought he was pretty much smarter than everybody, pretty much.
And what sort of thing did you hear that caused you to believe that?
Just the things that he said about, like, eventually when he talked about his case, or how he would deny things, but thought that he was going to beat the case, actually, and that you guys were trying to frame him and he was going to get out.
Who did he say was framing him? Do you remember?
He said the police framed him.
Did he say how they had framed him, what they had done?
No, he just said that they was planting evidence and trying to put something on him that he didn't do.
All right, so he indicated to you specifically that the police had planted evidence?
Correct.
Was that said to you once or more than once?
Said a few times.
Okay. And can you indicate any ways that you and he helped each other out? In other words, anything that caused you and him to begin to trust each other for any reason?
Well, when I was in the cell, like I said, we became close. Sometimes, like, if I needed him, he would come through for me, and if he needed me, I would come through for him.
And give me an example of the kind of ways you mean.
Like the first time ever was, because he usually don't share or do nothing or order much. He holds on to the stuff that he have. He had some food that I needed to cook with at the time, which was tuna. And I asked him, could I get the tuna? And I would order him, 4 back for the tuna, because he did it before with other people, and some people didn't come through on the end. And I showed him that I come through.
So, Your Honor, Mr. Washington is sort of soft-spoken and the words come out kind of quickly. Can we just ask the jury, can they understand him so far? I just want to be sure that they're able to understand him.
Sounds like it.
Okay, good. So, Mr. Washington, it sounds like you negotiated a loan kind of thing, right? You pay me now or I'll pay you later kind of a deal.
Sir.
Okay. Was there a point where, in discussing the defendant's case, that he talked about any involvement of his brothers?
Yes. He said that he couldn't have contact with his brothers because you guys basically try to say that they had something to do with whatever he had going on with his case, but he didn't.
And did he indicate to you, did his brothers have anything to do with any of this?
He said they didn't.
Okay. So how was he acting about that? Was he sad? Was he very calm about that? What was his reaction to the idea that
Judge,
hold on, let me finish. That his brothers would be involved?
Judge, objection leading, and he's been doing it repeatedly. I let it go, but definitely leading.
So I've directed him to a topic, and then I've asked what, if anything, was said about that. That's not leading.
And then gave 4 options.
Well,
And if I
no. I think it could be less leading.
Okay, so what, if any, reaction did the defendant have to the issue of his brothers being suggested as being involved in this incident?
Well, he was angry about it. He was mad, actually pissed off. I don't know if I could say that.
Okay.
But
And were you able to find out some personal details about the defendant's background?
yes, I was.
Okay, so what, if anything, did you come to know about his family in terms of who he got along with, those kind of things?
I found out that, he had brothers. He had supposedly have a sister or something. I don't recall a sister. I don't know if it's a sister or not. Him and his dad wasn't close growing up. He lived with him or something like that, but, they didn't have always good relationship. He told me that they fought one time. You know, he was tough on him and his brothers, stuff like that.
Did he say anything about anyone dying?
He mentioned something about somebody passing away, but I don't remember who it was.
And did he indicate whether that was a problem for him with his own family?
Not that I could recall. I just know that he said he was split up. He wasn't with his mom or his dad. I don't know how he got split up or what was the reason why he was split up.
Did he tell you in terms of sort of everyday jobs, not doing illegal stuff, but as terms of everyday jobs, what sort of professions he had worked in?
Yes, he told me that he was in he was like did cabling and construction work like that.
Okay, the first one was cableman.
Yeah.
Okay, and the other was construction.
Correct.
And then, did you have any topics that you felt like the two of you bonded over? You had some things in common.
Yes.
What was that?
Illegal things.
Okay, so what?
Objection. I think we've revisited this before. I think I'd have to be heard outside the presence of the jury here.
What would the relevance of this particular answer be?
Okay, do you want me to? I would reveal a lot of details by saying it. I will if the court wants me to, but I want to be careful.
That time again? This shouldn't be long. Going to talk about the case.
I'm trying not to act like a child. Well, at least Dingleberry had enough. Oops, I'm listening to myself on my other thing here. At least Dingleberry kept his comments quiet until the jury left.
Oh, right.
Okay.
So,
Mute.
Well, the objection.
So the objection, Judge, was that, and I was concerned about this as I read the reports, not only from the interview that Mr. Washington had with Mr. Gravely, but from the debriefs that that there was some discussion supposedly between the two, Mr. Anderson and Mr. Washington, about what the very things that we were worried about before, accusations of drug dealing, the other case he has. And so when he asked about other regular jobs, I thought, okay, we're going to avoid that. I thought we were going to avoid it. But then the very next question was, his answer was about what else did you discuss about, I don't know if it was about work or whatever, but it was, and I think he just said illegal things or about what they bonded over. And so clearly that's where it's going, or, maybe we can nip it in the bud here, but that's the reports from his interviews, in at least a portion of it, involve talking about Zach's other case and, going back and forth from California, that sort of thing.
Gravely.
yeah, so I do intend to bring these details up. So this is not something that I'm doing accidentally. So Mr. Washington has indicated in his debriefing to us in our discussions with him, and this is revealed in the reports, that the reason these two bonded, the reason that they felt they could confide in each other, was their shared discussions about the drug business that they had been involved in. So, just like you might say as an inmate in the jail, I bonded over fishing, or as an inmate in the jail, I bonded because we went to the same high school. This is how these individuals bonded. I mean, this is the true facts that was described. And some of the details that Marquand Washington knows are things that are not in a criminal complaint. They're details which reveal that Marquand Washington had real conversations with the defendant. Not that he is just an individual who could come in here and be a mercenary and just describe some facts that he read in a newspaper article. And I just want to give you a couple examples of that. He said he caught a case going back and forth from California. But he's not worried because it's not that much. He's right. In the context of these sorts of cases, it's not as much marijuana as many cases are. And it is a case where he's caught, presumably coming from California or from the West Coast. So again, this is something Marquand Washington knows that he wouldn't know through any other source. The next one is that the police in this case raided his house, took a bunch of money from him, but just a little bit of weed. Again, in the context of these gentlemen, this is 2 pounds of weed, which is not a lot of weed in the context of what you've heard, but it is more than $47,000. So it's a lot of money. And so again, this is something that Marquand Washington knows because they've had common discussions about the drug trade and what they have each done within the drug trade. The jury has no other reason to presuppose that Marquand Washington would bond with the defendant. They have no other logical connection. They did not grow up in the same city, et cetera, et cetera. And this is the actual answer offered by Marquand Washington when he was asked the question, how did you guys come to bond? He said, we bonded over our discussions of our various activities in the drug trade. And that is the answer he offered as to why he knows those kind of details. So again, Judge, this is, the jury has already heard and been permitted to hear that he was on bond on a matter in South Dakota. They've already been permitted to hear that there was a grow operation that had gone on at his home. So there are facts already in evidence in this case. This is not information that will be a shock to the jury or is that, but it has a very specific purpose to let them know Marquand Washington has some reason to know or have some reason to have these details at his disposal.
Judge, this is a pretty not very transparent attempt to backdoor some other acts. There was no motion about this, and just because they do a debrief with some informant that they want to call as a witness doesn't mean it's all admissible. Just because that's how they bonded, that doesn't make it admissible. That doesn't make it anything other than what it is, which is another act, which requires a motion before the court and a ruling by the court. And none of that was done. All of this stuff was widely available in the media. It's on the complaints. It's all public information. So, the fact that, even besides the fact that they need to fit it into another acts analysis, it's and it's not relevant. It's still not something that goes to prove what they're purporting it to prove, which was the bonding.
I want to indicate again that counsel's made an argument that this information is in the criminal complaint. I don't think there's any mention of the money in the criminal complaint or that marijuana was recovered in the complaint. Do you agree?
I'm working through all the pages, but
and I'm not aware that the complaint has any details about the defendant's involvement in the drug trade. The only thing it says is that there is a conviction in South Dakota because, of course, it alleges him to be a repeater.
I said the news media and the complaints.
Again, I'm not aware of any specific coverage, and maybe you guys are aware of it, and I don't know it, but I'm not aware of any specific coverage about his drug activities that have occurred in the media.
Yeah, and I was referring to the Zaki County complaint also.
Okay.
It sounds to me like evidence which is generally inadmissible. Other crimes, wrongs, and eggs.
I missed the last part. Apologize. You kind of your voice. We lost your voice.
Everyone should be so lucky. It sounds to me like you want me to let in evidence which is typically barred by the rules because of the risk of the defendant being branded as generally a criminal personality or having a character trait of criminality. And in order to bolster the testimony that he committed a crime in this case, which is dissimilar entirely from the bolstering evidence, I have to say I understand the logic of your position. What I don't recall is any time this has ever been permitted, nor any time that I've read in a decision or a treatise that this would be a permitted use. Now, I understand those have swollen a great deal in the last 50 years, the usage of these types of materials, but the general rule is still one of exclusion. From the fear.
So,
yeah, go ahead.
yeah, so there's a warrant done in this case, which is part of this case. So it's not another act, there's a warrant done, right? Found in the warrant is 2 pounds of marijuana, okay? Substantial amount of marijuana for any kind of, for any kind of typical drug investigation. There are a number of items that certainly anybody involved in this case would identify as marijuana seeds. The daughter of the defendant provides information that while she is staying at the house, which are on visits, that the defendant is involved in the cultivating and manufacturing of, and she actually knows the specific number. She can say of 72 plants. The daughter knows more about the cultivation and production of marijuana as an interviewed 12-year-old than I do. And goes through detail about that in her discussion with law enforcement about her father, the defendant, and his conduct. The defendant, we've already said in this case, the defendant is on bond in South Dakota on an offense. So the jury already knows there's a warrant, drugs are found, they know that there's bags of material out there that were the soil from a marijuana grow. They know that they've heard already that there was a marijuana grow that had taken place at this residence. So these are facts that are already in the jury's sphere. And, frankly, Judge, we're in a situation now where persons who are in the marijuana business often are doing that legally in many places. I can't remember what the vote was in Kenosha County for legalization, but it was significant. I want to say it was 60% plus in Kenosha County. And so I don't think we live in a world now where I have no evidence, by the way, so I'm not aware of any time that Marquand Washington would indicate that anything other than marijuana was involved in the defendant's dealing. So we're not talking about a guy who Marquand Washington will say was dealing fentanyl or was dealing even cocaine. So they're talking about quantity marijuana business, which is the way that these two first had their substantive discussions about what they have been up to in life. It is the icebreaker for these two individuals, Judge. You don't get to, you don't go right away to, hey, have you committed a murder? You have some discussions about what each of you have done to get you. That's the icebreaker. And frankly, marijuana is not held in such disdain now, or with such acrimony that I think that there's any realistic feeling that there's prejudicial effect for the defendant. I'm not ever going to argue, and I don't think anybody would ever argue, because the defendant has marijuana involvement, therefore he murdered, and this was a discussion we had earlier, Judge, on a different day, where the court asked me, are you, and the defense, are you saying that there's a connection here of the marijuana business to this offense? And we have said no. What we've said is that they opened the door by showing some bags and asking, cops, why didn't you search this? And those kind of things. But in this case, we're not talking about doors being open, but we are talking about evidence that they already have, that the jury has already heard. This is just supplemental evidence to this. And it is the direct, honest, real, and truthful answer that it's the icebreaker.
Don't use the word honest.
I apologize.
That's not for me to decide.
Okay. It is and so I shouldn't use truthful either. It is the offered answer by Marquand Washington about why we were able to have any discussions about things.
But the problem is we have to realize that the rules generally exclude this propensity evidence. It is clearly barred in order to prove that the defendant has got a character trait or
Totally agree.
Propensity to commit any crime.
Totally agree.
And there are a number of exceptions. If you go to the textbooks, Professor McCormick said it has to, for admission, it has to bear the signature of the accused in identity cases. It has to be the type of crime that is actually his signature. We all watched Home Alone at Christmas time again, and that I don't remember their names, but the guy who was not so smart always wants to leave the water running. It's his signature at the crime scene. And that's what McCormick, the Woody case, that is beautiful example. This deviant approaches children on different occasions and says, "Help me find this black and white rabbit," and that's how he gets contact with the children. It's his signature. We're not using it for that purpose here. What you're asking me is to admit this, and I'm not saying you're illogical, but you admit it to show the trust that these two have with one another, that they've bonded. So the criminality that they're discussing, the witness more believable.
So the court agrees it's relevant because bonding would be relevant.
If I could be heard, because
Well, yeah, all right.
Yeah, thank you. So there was a limited inquiry earlier over objection, but now what's clear, not only are you correct, this is another act, as we discussed, clearly barred, but now it's also clear that this isn't some supplemental, to use the state's term, this isn't some supplemental offering. This is like turning into the main aspect of their case. And he keeps talking about how there's all this marijuana at the house. Well, we don't know that. None of it's been tested. And it's a separate case.
But I do agree with his observation that people are feel very differently about marijuana, whether it is or isn't. The governor has proposed to make it legal. I was just reading the budget portion yesterday. It's supposedly legal in the state of Illinois. The president has proposed that it be legal. And public attitudes have very clearly changed so that what was once viewed as a very, very serious matter is not looked upon that way. Even people who oppose its legalization will get on TV and joke about it and about their own experiences with it.
And
So it's not what it once was.
And I think that's true, but in terms of its admissibility. So I think the court is on point with the fact that this is, in essence, it's, no matter how the state wants to couch it, it's still character evidence, and it's still there they're trying to get it in sideways for an improper purpose, and it needs to be excluded. And they need to be on notice that they can't do this with Sadie, and they can't do this with his daughter, because they're full, as he just said, they fully intend to do that.
Yeah, we do intend to do it through Olivia. I don't think Sadie has anything to do with this, but Olivia is going to indicate that all of these things occur, and if Olivia is lying about her father's activities in terms of all the rest of this, how odd that she would be telling the truth about the marijuana that was grown there, that evidence was discovered of. That's not a distinct another act. That is conduct going on when this case occurs. If we were in the same county, Judge, it would be in the same complaint. It's just that it happens to be in a different county, that it's not in the complaint. So that's not a distinct behavior that's different, and it's simply something that can't be charged here because we don't have venue on that. And in fact, it is a charged case, I guess, in Ozaukee County, right? But I don't think it is any distinct other act, Judge. It is these two indicating, here's how I do it, here's how I do it. We're not saying. And then he told me in January of 21 he did this, and then he told me of this. So it's not distinct sort of specific acts or specific items.
Why not? They're acts.
Well,
it's talking about.
It's generic. It's how I do it. It's how I do it. Kind of. That's the sort of information.
But there are other crimes, wrongs, and acts. I mean, it's even if it weren't a crime, it would be an act. It's character evidence, and the general rule is exclusion, except for specific aspects which are admissible for legitimate purposes. And what's getting me, and this is what I was trying to get at before, in all of the encounters I've had with this type of evidence, which is frequent. I've had it argued as proof of motive, it's proof of identity, it's proof of modus operandi, it's proof of this, that, and the other thing. It's proof. It even became, after many years of judicial resistance, it's become proof of veracity. Now you're offering it to me as proof that this is a believable witness, that he was bragging about his criminal behavior with the defendant who was bragging about his.
It does. It is used for the purpose of bolstering the credibility of this reporting witness, which is one of the purposes Whitty is permitted for. To bolster credibility.
It bolsters his credibility?
To bolster the credibility of a reporting witness, yes. So, for instance, in sexual assault cases, Judge, you're allowed to bolster the credibility of a reporting witness. So, I guess what I'm going to ask the court to do is let me, as I did last night, try to dazzle you with a case, which the court will strongly consider in the morning. So, I will do the research, and I'll try to bring the court, because there's a body of law under Whitty. Under 90404, which allows for a valid purpose of other acts evidence to bolster the credibility of a reporting witness.
So Judge,
like to be able to do that.
So he's now pivoting very quickly under your fire that now it's not just the bonding. Now it's part of Whitty. Now it's part of Sullivan. Now it's proper under the other acts, even though it's not an other act. So he's trying to, I guess, run parallel paths here. But the bottom line is that we all know it's another act. And that requires a pretrial motion, not something on the fly during trial. And even if we just ignore his comments about how it's not another act, he doesn't get to just come up with a case and try and argue it. And this is not some incidental thing to his case. He's made it clear. He wants to do it through Mr. Washington. He wants to do it through Olivia. He's already done it to a lesser extent in prior witnesses. So he wants to turn this into a drug case and to smear Mr. Anderson's character, pure and simple. And that is exactly, precisely what 90404 is about, and to prevent.
So, Judge, counsel, has indicated that I think has indicated there's something untoward for me to make an argument about what I believe that the presentation of the evidence is, and then in response to the court, when the court suggests comments from the bench, you're the guy wearing the robe, and you say things like, "Well, I consider other acts, etc." It feels like it's not dishonest for the prosecution to then say, "Well, then, Judge, I'd like to be able to present you a Whitty case because there's body of law." I don't think it's a dishonest change of argument to listen closely to what the court says, to understand what the basic parameters and guidelines are of the court's current thinking, and to try to respond to that. I wonder why we would need to have the quality of our debate here be that those kind of things appear to be dishonest. I've cited nothing that's wrong.
I don't want to get into
Sure.
these attributions
Okay.
about, it's pretty clear that you people have not been on the same track with respect to how to handle the case. And I don't care.
Right.
But what is this case that's going to dazzle me? What's it going to tell me?
While they're looking, that's the reason we have pretrial motions, so we can rationally do research, present it to the court, have a hearing, and not something where we're just changing our theory mid-sentence and then try and find a case quick.
So the counsel said that this case was all about the drug evidence, and of course this case is all about the DNA evidence. So Judge, we suggest to the court that I believe I'm aware that there are cases as I have purported. I don't need to repeat it. There is also a possibility that what's called panorama evidence, in other words, setting the circumstances. Again, I've already outlined why I think this meets the credibility, would also be a valid, witty place. So again, Judge, I'd like an opportunity to convince you by showing you a case or two that puts us in that position before we go any farther and not have this allowed. I think it's important evidence in this respect. I don't know why a jury would believe guys who spent 5 weeks together have bonded enough for a murder to be confessed to them unless there's something that is a middle ground. I don't need to repeat that again in any detail. I think the court has heard me and understands that there's relevance in that respect. And so now I just want to see if I can find a case, now that I understand that the court feels it's other acts, which was not my first thought process.
Well, there was a scheduling order in this case to file these motions. Enough said, right?
Well,
And for what it's worth, I've litigated other acts motions for decades, and I'm very positive that the first prong of the proper purpose has never, ever, ever included bolstering a witness. Ever.
I think it's admissible since maybe the early 90s. It's admissible for veracity, to bolster veracity.
Well,
I mean, counsel's indication that he doesn't believe any of these cases exist is exactly why we should talk about this. Because his argument is being made indicating he doesn't think there's a body of case law about this. I believe there is, and the court has just, I think, confirmed that. So,
Well, no, I didn't say that at all. What I said was that that this should have been brought pre-trial. It's clearly a huge part of his case, and he's trying to turn a murder case into a drug case. But he's actually trying to win a murder case by turning it, like by smearing it with the veneer of a drug case.
again,
That much is clear. He's not trying to bolster this witness's testimony. He's trying to smear Mr. Anderson's reputation.
these arguments with this rhetoric, Judge, should be admonished by the court.
I'm more busy right now. Well, the purposes for which, and I do think it's other acts evidence. Otherwise, it would be irrelevant. Motive, opportunity, intent, preparation, or plan. Oh, these are the ones that are both in the statute and then in Instruction 275. Which is suggestive of other uses. Knowledge, identity, absence of mistake or accident, context or background. And then it says identify other issue. So there are, as we know, there are other issues. And then there was case law, I think in the late 80s, early 90s, that recognized it could be used to bolster the witness's credibility, but I didn't think that the language of any case was sweeping enough to extend to allowing to testify as to braggadocio that he and the defendant exchanged to prove the accuracy of unlawful behavior of the defendant, for which he's not on trial. It's not to be considered to conclude that the defendant has a certain character or a certain character trait and that he acted in conformity with that trait or character with respect to the offense charged. So that's...
Delivery of marijuana does not equal murder. I mean, no,
correctamundo.
So I'm not asserting it for the purpose of indicating it makes it more likely.
So it becomes relevant because during the course of the discussions,
electrify your metabolism back to teenage levels by eating 1/2 teaspoon of this with ice water and burning fat like you're still in high school.
And you could introduce
Every
those
adult human always has around 30 billion fat cells.
But you fear he's less believable then. Has a certain character.
Right, and I'm looking to bolster his credibility. That's exactly it.
And you have some. What was the word you used? The adjective. Dazzling. Case law to support.
Well, and it was, of course, a word that was based on a reaction to my State v. Weed submission first thing this morning. So I'm still suffering the wounds from that experience and asking the court to let me repeat it in the morning.
So Judge, if I could, even if we get to that far, he can't bolster. I mean, even if those cases exist and it's more sweeping than maybe we recall or whatever, you can't bolster until it's been attacked of a witness.
That is the general rule.
Yes. So clearly,
Maybe that's by the case.
It's his witness right now.
I will be shocked if the defense concedes that that Mr. Washington is truthful and is telling no lies. And so I am anticipating, I think with good reason, that Mr. Washington will be challenged aggressively and his honesty will be placed into question. I don't think I misread any signs here, and I think the court can, in anticipating the evidence, understand that. Just as we would anticipate anyone in this circumstance, Mr. Washington's circumstance, would be attacked when he reports that the defendant has admitted a crime.
I don't buy into your basic precept, which is the fact that these two jailmates, with nothing better to do than to talk about their past exploits, are bragging about their drug crimes, and that somehow makes them more believable. This is supposed to be evidence which is supportive of the state's case without painting the defendant as a bad actor. And it appears to me it would have the purpose, even though I agree it's less serious than it was once viewed. It accomplishes the purpose of painting the defendant as a bad actor. It also, no, it doesn't either. But but at the same time, it's what is offered as the support, as the bolstering, is someone bragging about his criminal acts. Now, that's actually not why you're offering. You're offering it to they're relaxing their safeguards, and but boy, the rule was created for a reason, and we can stop now. It's okay with me.
Well,
and you can bring in case in the morning, and of course, I'm
from a variety of sources. I am receiving cases, so I feel confident I'll be able to bring something to the court. I have a number of persons who are interested in being of assistance on this issue. So I'm asking the court to break now before the court makes a ruling on this. And obviously we're not going to finish this witness today anyway. The court was going to finish at 4:30. I'm asking the court to let us break now, and we'll revisit this with whatever we can find.
For whatever it's worth, I'd like to continue.
Well,
with a granting our objection and prohibiting them from going forward with this theory.
I want to do it right, and I want to do it right, and this is why I do my thinking out loud and have these discussions, because people get my mind changed. I think I've changed my mind already in this case once or twice. So maybe he will dazzle me with some case, or maybe you'll bring some blockbuster. I don't know, but it's pretty clear what my present feeling is. We can wait till tomorrow.
Judge, the defense would request similar to how when the state objected during my opening statement and wanted to brief the issue, we had till 9 p.m. to provide something to the other party.
Yeah.
I'd ask that if the state's going to be presenting anything to this court in the morning on this issue, that similar courtesy be extended and that they provide that information to the defense by 9 p.m. this evening.
What do you think about that?
Well, I'm not able to comply with that because I teach at Parkside tonight, and so I have obligations from 5:40 to 8:45 tonight. But I do volunteer to place. I'll suggest any cases briefly as soon as I can this evening, and then or first thing in the morning if I need to do that. That's my request.
Judge, they have a whole office. There's another prosecutor sitting right next to them. I think they can get that done, especially since it's their burden and they're the ones that are wanting to,
Well, but we're
brief
talking
this and
now
interrupt
about,
it.
See, while I do understand that you, like everybody else, like to sleep, I happen to be going to a meeting, and where I won't have to be dealing with this. I think there's only one other lawyer in the group, so I'll get some relief. And I'll be in that meeting until about 8. So, and I wouldn't reach anything that got submitted until 10 at the earliest. So let's make it 10:30. And
We make it 9:30. I go to bed early.
read it in the morning.
Huh?
Read it in the morning.
Judge, we just want to be, sorry, Attorney Miller speaking. We just want to be prepared. They've said that this case exists. We surely are capable attorneys that can do our own legal research on the issue. But if they're going to be presenting a very specific, nuanced issue, and we don't get that case law until very late hours after we've all gone to bed or early morning, we want to be able to make sure that we have a legitimate argument based in authority to this court.
And the bottom line is that I'm first off, when I graduated and came into trying cases, we were still working on the ambush system, and frankly, I thought it was more fun than now. But I understand it had many shortcomings. The fact that the fact that something comes in at 10 at night, give you some time. It's not like we're exploring some expansive area of the law. We're in a very, there's a lot of cases on it. There are more cases on this than anything else. There always are. And the prosecutors have been pushing this further and further away from the original rule for a long time. So there's a lot of law on it, but this is a first for me, and yeah, that's a really good idea. Ask them to come in. Are they just in the back room?
Yes.
And then could Mr. Washington then leave as soon as they have been allowed to leave? Mr.
Indeed.
Washington's on the stand.
In fact, he can leave.
Could he leave now?
Well, I don't want him to bump into them.
Which way are you
What?
taking him, this way or that way?
Bring the jurors in through here. Have him exit through there. You're done for the day, sir. Thank you.
Can you,
I'll see you in the morning.
so there's a keep separate so that you know, and can you have him brought at 9 o'clock tomorrow? Thanks.
I'm actually going to invite the jurors back at 9:30 because we're going to be
Okay, yeah.
Working tomorrow for, and we'll be luck out in a half an hour. All right. You're such a nice jury. You really are, and that's sincere. This is what's happening in this particular case is I've been here 40 years, and I've never had one like this. And I'm not blaming anybody. It's the way it is, and you people have been wonderful about it. I can tell you stories. So thank you for that. And we're moving ahead, and I'm going to actually ask you to come in at 9:30 tomorrow morning, because I know we're going to be going for a while here this afternoon, and we're going to not have a resolve. This particular subject we're talking about, I talked about hearsay and how much of the book it occupied. This particular area of the law we're talking about now is the most litigated area in the law. If you look at the appeals over the years in the various courts, this is far and away the most litigated. So there's a lot of legal work that is involved in this. So give us an extra half an hour tomorrow morning. I recommend an extra half an hour of sleep, but whatever's practical. And I know we're using your time, but we're getting there. Please report at 10:30, 9:30. Forgive me, 9:30. There were 11:30. There we go. Yeah, 9:30, and I'm going to make every effort to get you down here right away and get back onto this. Please don't read, watch, or listen to any account of the trial. Discuss the case with anyone, even members of your household or other jurors. Any questions, anybody? Okay, thank you very much. Now, well, where did I leave it at? By what time tonight? 10? 10 o'clock.
You did at one point say 10:30, but you might change tonight. I don't.
You know me. That's.
I think you changed it to 9. Maybe I misheard. I don't know.
All right.
I'm busy having games called me. I missed one.
I will. I'll make a Soloman-esque decision and say 9:15.
You each said 10 before.
Oh, I did.
That was what you just said.
Nine.
Look at this man's
All right.
sense of humor,
10 o'clock. 10
despite
o'clock.
all this shit dumped on his shoulders.
You're closing testimony tomorrow at 2:30 p.m. Is that what you said earlier?
We are. We're stopping at what I don't know where the testimony will be, but we are going to stop tomorrow at 2:30. Okay, 2:30, and I apologize. This was not first until a couple of days ago. And then I can come back at 4 and pick up. I'm not encouraging that because there is a judge's meeting with some issues that I would like to be there for. Although I'm sure Judge Gabrielle would do a wonderful job, even if I'm not there. Maybe. But
I don't even know.
but we can go at 4 o'clock if we have to.
Is it an appointment where it's possible that there be a wait as well without this detail? So is it possible that you might not make it back?
I
to
would not
4:15?
expect a lengthy
Okay.
wait.
My only concern is obviously this jury has gone in, out, waited, in, out.
Yep.
That for them to then wait around for an hour and a half, come back to then leave again.
Yeah, that's a good point.
I just want to agree with the defense on something, so I'm going to join it.
Thanks, Mike.
Fair enough. So we will.
I disagree.
We'll
Let's
wrap
talk about
it.
it.
We'll wrap it up at 2:30 tomorrow.
You remember the good old days of the stipulation? Remember those days?
Oh, yeah.
That was a while ago.
But I
This is the moment of our live stream where we reflect on the fact that it has been 1,319 days since the defendant has been incarcerated. I hope you enjoyed my muteness. Although I did enable mute capping, like cap letters. Here's just an observation. Well, and a request, frankly. I would hope that some people would come and join us that think that he is guilty beyond a reasonable doubt. I find it hard to believe that unless you sat here like we've been doing these past however many days and listened to the whole entire thing, I find it hard to believe that from what we've seen so far, we're on day 7 of 17. We're not even halfway there. That the burden has been met, that it was first degree premeditated along with the other charges. Hopefully that makes sense. I told my daughter the same thing because, you know, they're the youth that like to just like read the headlines. Oh, look, he's guilty, and, you know, move on. So there's my comment. I kind of wish there was more people in here that think he's guilty. Because wouldn't that be something if we could, you know, go through this together? You know, Steven Crowder does that all the time with like change my mind. Hopefully that makes sense. So this day here is only 3.5 hours. So I'm guessing, what time is it? It's not quite 6. So I'm guessing we'll just continue. Since we had that technical glitch about an hour and 45 minutes ago, looks like everything, I shouldn't, just, never mind. Anyway, so I had some other comments. I encourage you to go get a glass of water, coffee, tea, cocktail. Do a little stretching. Do you guys ever watch, have you ever heard of iPod 1776? In a sense. And he always had these clever little, you know, that gif of like the guys from like the 80s in their like shiny blue spandex doing like jazzercise. He'd have that like, do your stretching. It's time to get prepared. All right. Thank you for being here. Again, sorry about the glitch earlier. Sandra, 44. Welcome. I just watched Rittenhouse. Kenosha DA's office is so corrupt. Gravely, I think he is worse than... Oh no. Who's Bingley? I never watched Rittenhouse. You're telling me that it's like an epidemic over there? Are there Gravely clones, let's just say? Another thing, if I can find my pen. Okay, so there are certain sticking points with respect to the evidence. Also, there are certain things, in my opinion, that have been like deceitfully repeated or misrepresented, shall we say. And I think some of these, like certain pieces of evidence, I know I see carpet a lot, and I see the burn pit a lot. I also see the stalking comment a lot. So it'd be interesting to take the time, if I can remember, to like just take certain clips of the actual testimony, actually even just like use parts of the transcript with like timestamps. I think that would like be able to, and people can watch it and like, because I mean, there are certain things that, oh yeah, it's just kind of don't know. There are certain parts of even I've wanted to like rewatch some of this because I do get a little distracted with all the technical stuff back here, and you know, I have a problem with like the squirrels. So, and then sometimes my rage builds, and then I can't focus on what people are saying because I'm trying to comment on some sort of thing that I've seen that I find unjust. I don't know if that makes any sense. Yeah, the carpet seems to come up a lot. I don't know, bring your friends. If you think he is guilty beyond a reasonable doubt, bring your friends. I think we should watch it together. I love a healthy debate. That's why I like politics so much. Actually, if I was bold enough, I'd be like Dan Bongino and like try to moderate two opposing sides in like a verbal discussion. But I don't know, that probably won't help. Won't help. Okay. All right. So I'm assuming Munch returns and more. Okay. I'd also like to take this opportunity to thank Vielhammer Media, who has remastered this video. His link is in the description box below. And he's actually got his logo above my head. I don't even have my own. That's how much I appreciate Vielhammer's masterfulness. Here, underneath, okay, underneath the description box here is his channel, along with the playlist, which has all of the remastered videos in a row. And if I've noticed that he puts the testimony of the witnesses in his description box. So it looks like we got Marquand coming back up. Then Kayla Petty, who is Rosalio's former partner and daughter's mother. Susan Brown Williamson, Zach's employer. And Andrew Schultz, Zach's friend. Called for the state's witnesses to testify against Zachary? ? All right. Back to business. I appreciate you being here. I haven't seen Sadie today. Did she decide not to grace us with her presence? Okay, here.
The state had inquired that they would do some research, send over cases. We've received the cases, reviewed them. So really, I guess it's up to the court who you'd like to hear from first.
Well, oh. Really?
Thanks, Judge. So the first thing I want to make clear is that I hope the court will draw a distinction between two types of evidence Marquand Washington provides on this general topic of drug activity. One thing that Mr. Washington has provided to law enforcement and disclosed in a report provided to the defense is that the bonding between these two individuals occurred over drug dealing, that both of them recounted their activities with prior drugs, and I believe that in regards to the defendant here to be marijuana. So the defendant is purported to have said to Mr. Washington that he had connections in Detroit and California, and that he used to transport hundreds of pounds of marijuana back and forth to California. So, you know, that would be historical information, which would be the defendant's side of the reporting that Marquand Washington said, I was also describing my activities with him. That's how we came to sort of trust each other and reveal details to each other. So we didn't just bond over I think it was tuna that he said was the other way that they bonded, but because they were discussing mutual past activities. So that is one thing that I'm asking the court to allow. I do think there's some distinction between then what he reported about the direct circumstances that are revealed in this case, so this investigation, right? So things that are contemporaneous with our case. And Marquand Washington, and from the state's perspective, those things reveal to a jury that Marquand Washington has inside information that he would not have unless there was some confidence being expressed, right? So it makes his details about any confession more believable because he has details about other circumstances of this investigation that would not be readily available, okay? So those details are that the defendant had caught a case going back and forth from California, but not worried about it because there's not much, because it wasn't that much. So we know that the defendant had a pending case in South Dakota where he had transported pounds of marijuana from the West Coast. But it wasn't substantial, you know, it wasn't hundreds of pounds, it wasn't even dozens of pounds of marijuana. So from this, I think it's 10 pounds, right? Oh, apologize. Well, it is an amount of marijuana that would, in the context of people talking about hundreds of pounds, would not be as significant. And I have I can tell the court what it is. But anyway, and as the court knows, Mr. Remsburg has also already testified. I accompanied him to South Dakota for a case. Now, this Marquand Washington doesn't know it's from South Dakota. He just knows he caught a case and that in perspective, it's, you know, not a major deal. Again, it reveals a confidence, right? Reveals something that is not, that's not available, for instance, in the criminal complaint, where it indicates he's been convicted of a case but doesn't provide any of the details about that. Then there's the piece about what he describes as the police raid of the defendant's home, okay? So what Marquand Washington says is the defendant told me the police raided my home and they got a lot of money but a little weed, okay? And of course, what's found in this raid by the police search warrant search is 2 pounds of marijuana. It's the seeds the court saw in the picture that's in evidence, and more than $47,000 in cash. None of those details are in the criminal complaint. None of them. And I'm not aware of them being in any coverage that I have seen of this case. In other words, what was specifically obtained in that search warrant. We didn't charge the drugs, right? So it wouldn't logically be a part of our criminal complaint. But the $47,000 is also not in the criminal complaint. So Marquand Washington knows that fact without it being in the criminal complaint. And from the state's perspective, that provides me an opportunity to argue to this jury based on things that are in this investigation, not separate and distinct drug, cases, not a month ago, a year ago, whatever. It allows me to show that he has some credibility in having heard some confidences from the defendant, such that you might say to yourself that a person might get to a point where they might go as far as admitting some complicity in a homicide. so I'm going to suggest first that the state's decision-making in this case was really defined by the case State v. Dukes, which is one of the cases I submitted. And I think that the legal phrase that you hear nowadays is called panorama evidence. And I don't commonly use that phrase, but I understand it to be, as defined in Dukes and as I thought about this case, that you don't need another Acts motion if you are describing circumstances and conduct, and I'm including criminal conduct, that is being used to explain items that are of interest to a jury and would be important for a jury to understand. And so in the Dukes case, as the court knows, the prosecutor did not file another Acts motion. The prosecutor is introducing evidence of activities that were happening around a house that police believe is a drug house during the time period of around May 27th. The criminal case itself is about a search warrant that occurred on June 26th, so a month later. The defense, very strenuously, argues this absolutely should be another act. It's other bad conduct that you're alleging at this residence and connected to our defendant, and you are using this to show that he's in conformity with the same activity. In this situation, it has some similarity in conduct, so it's probably even more something that would be at least on its very surface the kind of thing that you would think might be other acts, right? Because it would be an identity type of thought process in terms of another acts analysis. But the court in that published decision, of course, the Court of Appeals, indicates very strongly that they do not believe this to be other acts evidence. They don't do that based on the similarity. That's not their analysis. It's not analysis based on 90404. In fact, they reject 90404 being the criteria that you would use. Now, obviously, they do an analysis about whether it's unduly prejudicial, right? So, and I invite the court to do that in this case and to think about whether drug activity is something that's unduly prejudicial in a murder case, whether there's any propensity sort of worries about that, and whether a limiting instruction, as is recommended in all the cases I cited to the court, is a appropriate and strong and considered a definitely helpful remedy in terms of any misinterpretation or misuse by a jury. Obviously, the state's aware it's limited in its ability to argue that and understands that we can't do that. But in Dukes, paragraph 31, from the state's perspective, is the crux of the case.
Pause a moment. Since he's just yapping, I'm going to turn him on. Not literally, of course. I'm going to play the video. And then I'm going to just grab the transcript real quick while we listen to him drone on.
In terms of talking about all of that, and in terms of talking about whether
I don't even, I mean, I haven't really looked at these, but I don't know. It could help. It could come in handy, let's say.
It defines, in paragraph 31, unfair prejudice arises either when the evidence admitted has a tendency to influence the outcome of jury deliberations by the use of improper means, or when it arouses in a jury a sense of horror or desire to punish. Now, I just don't think the marijuana business is such that that is, at this point, a factor, particularly in a homicide case with these egregious set of facts, with the pictures of blood that these jurors have seen. And then it goes on to describe the evidence that is outlined in this case and why they believe
you may want to
that
avert
it is
your head. It is kind of
evidence. They say the evidence presented by Carter, that's the detective, informed the jury of police surveillance at the residence, that the behavior they had observed was consistent with the operations of a drug house, and that they searched a car because they suspected it contained drugs purchased. And
Did I get it all?
From that address, and their suspicions were confirmed. So what it does is it ties together why people did each of the things they did. It ties together why officers were appropriately making decisions they were at each of those stages. And it is used to bolster
Bolster.
Particular allegation that the defendant, in this case, possessed drugs with intent to deliver at a location when the search warrant was found. Now, the things I've talked about are not actually direct. So you know, it is a case that stands for the proposition that for collateral but important purposes that meet an appropriate definition of relevancy, that the court can admit this panorama evidence without utilizing another acts analysis. And that's where that's where I was. I do want to talk about the question of other acts briefly, because the court certainly, you know, before I cited these cases, was I thought was strongly inclined towards another acts analysis here. So I want to acknowledge that, and I want to talk about the cases that I think support admission of this evidence when the court considers the factors that are relevant in Sullivan. The case of Plymesser, court sexual assault case, right, 1992, talks about an ability to use other acts evidence to corroborate a victim's testimony. And, you know, it's victim in that case, but really it is the reporting witness. It's to bolster a crucial witness to the state. It's to bolster and corroborate their testimony. So when I talked about a line of cases, you know, that Plymesser case is an early manifestation of that particular situation. But the Dorsey case, and then I think even more particularly the Hunt case, also adopt that. The Dorsey case that I talked about is also another acts admission, and they're not just talking about a victim. They use language in Dorsey about the bolstering a witness's credibility. They say in paragraph 49 of State v. Dorsey, furthermore, to the extent that our case testimony operated to bolster CB's credibility, we have held that, this is in quotation mark, a witness's credibility is always consequential within the meaning of Wisconsin Statute 90401. So the court knows that 90401 is relevancy, right? So I'm going to suggest to the court that when considering this analysis of whether these things are relevant, State v. Dorsey, which is a state Supreme Court case. Yeah, I'm sorry, it's paragraph 49 and then into 50. So that what I just read, what I just quoted is paragraph 50. I apologize, counsel. So this is the 2018 state Supreme Court case, which defines a witness's credibility as always being consequential, which is one of the ways you define relevancy. So in this case, we have two witnesses whose credibility will be absolutely attacked in this case, and they're key cornerstones of the state's case. One is Marquand Washington. The jury issue here is he credible for any purposes that the jury can get a grasp on in reporting this individual confessed to me? Is he credible? And the evidence we're asking to introduce bolsters his credibility, which is endorsed by Hunt, Plymesser, and Dorsey in terms of in general. And Dorsey, the state Supreme Court, clearly said that if that is the case, it's relevant.
Well, I'm sorry to interrupt.
Okay, that's okay.
But I'm still struggling, as I was with yesterday, was with you've got a individual who's accused of multiple crimes, who's made some kind of a plea bargain with the government to cop a plea to some lesser charges, and one of the ingredients in the deal is he's got to testify in this case. And so we know on the one side there is an enormous incentive for him to come up with something. And I'm certainly not suggesting there aren't many people under those circumstances who follow through and testify truthfully. and the government got a good bargain. And I'm not suggesting the government shouldn't be in that kind of making those kind of arrangements with people. But in the end, you're asking me to find this jail inmate is more believable because more reliable because the defendant allegedly made some admissions to him about a crime that has nothing to do with what is an issue in this case. And I'm thinking, well, now, step out of the role of the DA for a minute. If you're looking around for a car and you stop at two different car lots and find vehicles that are substantially identical at the same price, and you know that one of the offerees is sitting in jail under circumstances such as this witness, are you going to consider him more believable because he's taken a deal to testify against somebody else on an uninvolved matter? You're going to consider him as the more believable of the two people you're dealing with? I'm not at your destination point.
Yeah, I'm certainly not, right? That is a valid argument, and it makes perfect sense as an argument about his credibility, and I'm certain the defense will cross vigorously on that and make a vigorous argument, and they should, right?
And it's a jury issue, and it's not for me to make.
And right,
the problem
and it isn't,
and it comes at a price.
Right. So Judge,
introducing evidence that this man has committed a crime totally uninvolved with the crime charged in this case. That is specifically barred by statute, except in limited other instances. Go ahead now.
Yeah, so I think the court has very articulately expressed what the compelling argument is about whether he's believable, and I am indicating that the appropriate ability to argue that there are elements of believability. The court's watched this many times, and I'm sure did it yourself. The way you bolster the credibility of an individual who certainly would be questionable in those ways, a co-defendant who testifies against someone, those kind of things, right, is you show specific information that...
Pause. I need to find my pause. Actually, I need to find pause that are colored, because our black pause, they don't really hold up over the video. Okay, so for those of you who are lawyers out there, I have a question. I mentioned this earlier in one of our earlier episodes, if you will. Here's my question. I know this varies by state. Again, this is coming from an accountant, not a lawyer, or anyone involved in law enforcement. But if there are two plausible scenarios, the evidence for both scenarios is there, even though we know it can't be. But let's say two plausible scenarios exist or are left on the table, if you will. Aren't you supposed to select which of those two plausible scenarios is in favor of the defendant? Question mark. I know that applies differently by state. So I'm kind of curious if that's part of Wisconsin's law, if anybody knows. Question mark. Thank you for your time. Now, let's continue.
They would not know unless the things they were reporting is true, right?
Well,
so that drug raid I'm talking about is an example of that, right? So just so we're on the same page. And also, if it's a person who's not intimately connected to you already, right? Then I think it's a valid argument for the defense to say, well, this guy's living with them for only 5 weeks. The inmate himself, Mr. Washington himself, says this guy was paranoid. He thought people were bugging his cell and things like that. He's not going to admit to this guy that he committed a homicide. What possible reason would a jury have to believe that? I think that's a very valid argument by the defense, right? And the reality is we have information that is offered by the inmate that this other activity that they mutually discuss is the reason that those barriers, you know, yesterday I said it was the icebreaker. So I respect and believe that all those arguments we just described, including the one you articulated, are totally appropriate. And
Pause. C-Swept basically answered my question. If there is a second plausible scenario, that is reasonable doubt. Exactly. I just remember that being part of the jury instructions for another high-profile case, and I found that interesting. We've all seen the episode of Matlock where he points to the back of the courtroom door and says, Mr. Dingleberry's going to come out the door right now, and points to the back of the courtroom, and everybody turns around, and he says, that is reasonable doubt. And then he sits down. So, that's a very good point, C-Swept. Thank you so much. I might make that into, I don't know, maybe a stinger.
The truth about how that could be answered, right? You know, considering that Mark Juan Washington may simply be telling the truth, Judge, right? Considering that this man might simply be telling the truth, to give the jury a chance to consider that based on the information we have, we would be having this discussion, right? So, and you know, in the Hunt case, which is the last case I want to mention about this, they talk about that other acts in this case. So this is another acts analysis, again respecting the court's discussion yesterday afternoon. The other acts in that situation are provided necessary background and to provide an independent source as to, in that case, the victim or the witness's credibility. So again, it's about the victim or the witness being someone whose credibility can be assessed by a jury. Jury doesn't know. In that case, the witness involved was recanting, right? So the question is, was their original discussion credible? And it is, the other acts are admitted, and the question the question there is, can we use this for the very specific 90404 sub 2 purpose, not delineated in the statute, but where it says or other means, right, is to bolster, in that case, a victim and a witness's credibility. So here we have, you know, I want to mention the one last piece in terms of a witness, and that is the daughter in this case. So she has just turned 12, just a few weeks past her 12th birthday when she speaks to law enforcement. The defense argument in this case is that 12-year-old has been coached and that her mother has provided her information and put her up to the allegations. That 12-year-old in a recorded interview indicates that my father had me participate in several things. I saw that he went inside the car. These are the stalking allegations. I saw that the paperwork that had been taken from Rosalio Gutierrez's car in my father's house. I saw that he brought me along in the middle of the night, leaving the children, the 4-year-old twins behind, to peek into my mother's living room when Rosalio Gutierrez was over at her house. I'm being asked to spot.
Pause. Think we need some pause. I've heard that so many times that the twins were left behind. What's the correct narrative on that? Bye, Alicia. It is so nice to see you. You know, normally I watch these trials in 1.25 times speed, but there's so much going on all over the place. I don't have the luxury of playing it a little faster. I was just curious about that narrative because I seem to see that a lot, that Zach, you know, left the kids behind, left the kids behind, left the kids behind. I'm kind of curious.
On my father, all these things.
So that I can correct that narrative if it's incorrect. Okay.
He has concocted a false story that we're going to tell to frame my mother into a child neglect type of charge. And as part of what she says, Judge, and as part of what she says, she says,
unpause.
And ultimately she says my father was involved in at his home, at the same place that the search warrant was done. He had a marijuana growing operation.
Pause. How does he know what all this stuff is if she hasn't testified yet? Question mark. Again, I count beans. I'm not in law enforcement or the legal profession. Is this because of her deposition, I'm assuming?
He was manufacturing mushrooms. Here's how the marijuana operation was growing.
Wait, pause again. So, okay, remember how I told you some of the trials in my short career have been, the judge has prohibited any sort of audio or visual outside the presence of the jurors. So I'm kind of sticking that in the back of my head because the jurors aren't in yet, correct? Question mark. And second of all, if we're hearing this, how many, let's just say millions of people probably watched this trial. I mean, it was on court TV, wasn't it? And so people outside of those 12 jurors are listening to all of this. And then maybe in the back of their head thinking some of this that maybe wasn't brought into the actual trial is fact. I don't know. I'm speaking aloud, which is what the judge does. And I don't want to go down that road.
She mentions 72 plants. She actually knows the number of plants that were involved. She knows more, as I told you yesterday, about marijuana cultivation and the manufacture of these substances than I do as a 12-year-old. And she says he just harvested, he just essentially stole the vast majority of what he had. And when the search warrant is done, all of those things are true. We have all the seeds. We find 2 pounds of marijuana. There is the potting soil with the remains that are in the bags out in the back. Again, if she's been put up to this.
Pause the second question. So I've heard several times in what we've watched today, the potting soil is for the Mary Jane growing. Okay, so let's just say, well, no. Was it tested? I mean, you would think that they'd be able to test the nutrients and what have you. I mean, if you'd had potting soil and had another plant in it already before, wouldn't there be some type of testing you could do to like figure out what kind of plant was growing in it? Was that done? If it was not done, then how is that evidence entered into the record? I don't know. I'm just thinking out. Again, I'm pulling a judge. I shouldn't do that, maybe.
Why is she able to be accurate about things we can independently confirm about that residence? This is very powerful evidence that this 12-year-old is a truth teller about things that certainly implicate her father in many, many ways in a homicide.
sorry, you're going to get repetitive pause while this Dingleberry talks, just because I'm starting to tune him out and I shouldn't. But Law Kong Express says, why would Sadie drop her child off at a drug operation? That's interesting. You said that because she, you know, they had a custody, some sort of arrangement at the time. You would think that she would have, you know, some sort of inkling as to what was, you know, going on. I mean, I dropped my kids off at my ex's when I, you know, when they didn't have their licenses, and vice versa, especially early. Now, granted, I wasn't given a, you know, warm welcome in, and vice versa, but you could still kind of get a inkling, you would think, or the kids would say something. But then all of a sudden, like, she changes her tune. And on top of it, okay, let's just go down this little short path. The stalking. You would think that she would have confided into, like, okay, so for example, let's take Nicole Simpson. She had photographs. She had all kinds of evidence. Is there any evidence other than that one videotape that was supposed to be, in my opinion, wasn't it kind of like a prank? I don't know.
So, and she also knows, Judge, the exact date that he will be going to South Dakota for sentencing on his multi-pound drug case. So she knows what it is, she knows what his offense is, and she knows the exact date and that he will be going to South Dakota. And that date, by the way, is just about, it's...
All right. Jen RN, also very closely related to this trial. Sadie is no stranger to drugs. Here's the thing. If you're going to enter into the record one person's history, let's say, shouldn't all actors be questioned about their, you know, past? I mean, I guess they did with this Marquand, which when I was on my self-muted portion of his testimony and then subsequently Gravely's ramblings, Dingleberry, I thought that was interesting. You know, Zach had outstanding something or other for the Mary Jane possession. And I don't know how much it was, but was it more than like 600 pounds like Marquand's federal offense? I mean, how can you throw that on him to try to, I don't know, muddy his reputation, find anything he says not credible, but yet you put on a federally charged witness with I forget how many kilos, but I remember the 600 pounds of the Mary Jane, and consider his testimony credible, and then subsequently what happened after that with him. Plus, like I said earlier, episode number 4 of the podcast, Wrongful, Law Kong is the voice of Zachariah Anderson, discussing how he was put into the hole so that they could toss all of his and destroy all of his stuff in his cell, and switched him to a different prison so that they could, quote unquote, break him. You're telling me they didn't use those same tactics on this Marquand to get him to turn, or snitch, or make up stories, or tell the truth, but
It's the 27th, so it's a week and a half away from the homicide date. This is not a 12-year-old who's being sheltered from her father's information or activities. She is being entwined in them in a way that, again, if those kinds of materials are not permissible, then she's being coached, does not have that whole body of evidence available that shows that she got a number of things right. So how would the coaching, doesn't that undermine this idea that she's not being truthful?
Pause. So I'm seeing some chatter about an arm that might have caught on fire. Reverse those two words. Or yesterday we called it a nug if you spell it backwards. And it's my understanding, I'm pretty sure from Solomon Anderson's interview with either Baker or MLS David, that Zachariah was not fond of, let's just call it the 2A, the things associated with the 2A. So there's that.
Well, I don't want to jump over on.
Becca Lynn. Okay, so my aloe vera. Okay. Becca Lynn says people really bond with their plants. I'm not going to lie to you. In my home, well, I used to have 6 plants named Rachel, Phoebe, Monica, Ross, Chandler, and Joey. Ross was the aloe vera plant because he was a doctor, even though we know he was a doctor of paleontology, but that's just what I went with. And Joey and Chandler are no longer with us, which is weird. But I also have a ponytail palm named Gidget. So yes, people do bond with their plants. I think it's a good thing.
Okay, well, I only
Great,
tell
now
you
I've
that
told you
because
3
for
secrets.
me,
I'm not going to
it's
have any
two-part.
stories
It's a
left by the
stool
end of
that
this
has
trial.
both legs. It's Marcon Washington's credibility, okay, which of course will be under vigorous challenge, and it's a 12-year-old daughter's credibility, who will of course be under vigorous challenge because she says some things that are highly damaging to her father, the defendant in this case. So the discussions we're having are necessary evidence to both.
Sorry, pause. La Kong Express says Zenith, so Zachariah's sister, was in town for the minor child's birthday. Initials OA, i.e. Zachariah and Sadie's oldest daughter. The twins were probably with her, meaning Zenith. Very insightful. I'm telling you, when you see La Kong Express's chat go across the screen, make sure you're reading it, because it's a clue or points you in the right direction or just flat out tells you.
Bolster both of those two persons' credibility, and I believe they are admissible based on the things I've indicated. Thank you.
Thank you. Defense?
Yes.
He talked for 25 minutes.
I want to talk about the fact that Attorney Gravely is arguing really 2 different things here, and I think the court was anticipating this a little bit yesterday afternoon when the court observed that this certainly does appear to be other acts evidence. The initial part of Attorney Gravely's argument was that Sullivan and Whitty are not part of this and that this really should be treated as panorama evidence. Now, I know that there have been many cases where that type of issue has permitted.
In case you are wondering, Gravely was 3,800 words in his statement there. I'm just kind of curious. I mean, I'm a numbers person. This is kind of fun for me. Kind of curious how that's going to play out here. If he's also going to get 3,800 words.
The introduction of evidence when the state can allege that it's necessary to put something into context. And in those cases where it is admissible, in other words, it's not other acts, but it's merely panorama evidence, it tends to be much less prejudicial and much more relevant in order to give meaning to other procedural or timeline aspects of a case.
Counsel, can you turn your mic on?
It is on.
Okay, speak.
I'm having trouble
People are having trouble
looking at the judge while I'm speaking sideways. So,
Who's in charge of this courtroom? Is Dingleberry in charge of the courtroom?
I'll move this way. I like to make eye contact with Your Honor, if that's okay. So, again, when we see these types of cases where the prosecution wants to offer evidence that will provide more meaning or context to facts surrounding, it tends to be on a timeline basis. And the case that Attorney Gravely was discussing, it was precisely that. It had to do with events that had occurred leading up to something that the prosecution was successful in arguing that it was necessary to do that so that the jury wouldn't be misled or something's taken out of context or being given a partial picture. Now, in this situation, we're talking about a wholly separate, categorically different type of evidence. And the reason that it's being offered, if we really are looking at it under this idea that it's to bolster the credibility of a witness, that falls within the other acts analysis. And
Okay, sometimes during subcommittee hearings, we do have a bingo card. If we do down the road in the next 10 days decide to have a bingo card, let's not put the word bolster on it. Or a drinking game of some sort on maybe New Year's Eve. I don't know. Okay, continue.
Point to the case of State versus Fink, 95, Wisconsin 2nd, 330, a Court of Appeals case from 1995. That case dealt with the prosecution did file an other acts motion, and it was 1 week before the trial started. And the issue there was, given that that was termed as an 11th hour motion, and the issue there was 1 week before trial is not enough notice for the defense to be able to anticipate that this will be what we always want to avoid in our other acts scenarios where Sullivan does apply, is a trial within a trial where the proponent of the evidence needs to present facts that the defense is entitled to adequate notice to not only investigate, work it into the theory of defense, work it into voir dire questions, potentially, as we probably should have in this case, but also so that we're not straying too far from what the central issue is in the case. And that's why 90404 exists, is so that we're not bleeding over into a controversy that is not part of what we're dealing with. I want to point out that all of the cases that we've looked at that deal with the concept of bolstering almost universally involve sexual assault cases, or they're trying to bolster the credibility of a victim in particular. And especially some of the recent cases on that issue, as the court is well aware, both statutorily and case law precedent supports the idea of the greater latitude rule, based on the premise that when there is a sexual assault or a victim of that type of situation.
You will be relieved to know that today, day 8, they only use the word bolster 20 times. For those of you keeping track.
The prosecution is given greater latitude to introduce evidence that would otherwise be barred as character evidence, inadmissible character evidence, for the specific purpose of painting the person as somebody who isn't as innocent as he might appear, to not put that particular aspect of it into isolation. And in those cases where there's been past allegations that have been investigated, or even past similar allegations against another person or the same person, the court should give greater latitude because of the nature of those types of cases and the nature of the victims involved there. So what we're really talking about here is the state hasn't provided notice, and that's why they're arguing, I assume, that this is panorama evidence, because panorama evidence doesn't require notice because it's less, by its nature, less prejudicial, right? Anytime we're dealing with somebody testifying about illegal activity, and I know we've had discussions about the fact that marijuana is not as vilified as perhaps it once was, it is still a discussion about illegal conduct, breaking the law. And there are many cases out there that talk about the fact that it's natural that it would draw opprobrium from the jury in those situations. If it's not specifically tied to something very important to a theory of prosecution. That's where we look at the 90404 and the many exceptions to the character evidence bar. Court's familiar with all of them. Motive, opportunity, intent, plan, modus operandi, those types of things that have traditionally been allowed as an exception to that character evidence bar. The important thing to note here is that just in addition to what Mr. Gravely was arguing, and by the way, I understand that it's his job to anticipate what the defense might argue, but we haven't argued any of the things that he's saying what the defense theory is. I think that's up to us to determine what our theory is and how we argue it, instead of having him speak on the defense team's behalf about what he thinks our theory is. Even if, and I think it's significant that he's explaining how he envisions all of this to be relevant to arguments that he anticipates that we're going to make, that's precisely the reason why an other acts motion should be filed before trial, is so that those issues can be worked out and so the court can perform a detailed Sullivan analysis and also determine the impact that this will have on the way that the proceedings occur. So it's clear that the state either thought that this was panorama evidence and wouldn't need to file that type of motion, but at the same time they're arguing that for the purpose of witness bolstering, which would theoretically fall under a 90404 analysis, that they should get it in that way as well. But another couple of points to note here. First of all, this information that the state is alleging that Mr. Washington could not have known about in any other way except for a statement from Mr. Anderson is contained in the criminal complaint for the Ozaukee County case. And in addition to that, I don't know that the state can prove that that only the media and only this one complaint were the potential sources of information from Mr. Washington. We're getting into speculation about how all that occurred. But a defendant's entitled to have discovery, letters from his attorneys, all types of information in his possession in the jail cell. So to just assume that the only thing that could have possibly been the source of this information and therefore makes this evidence so incredibly relevant is flawed at its base. The second part of that that's problematic here is that the state is alleging that because Mr. Washington knows all these details on this aspect of it, he must be believed on the heart of the matter, the root of what we're really getting at here, which is the alleged confession that Mr. Anderson did commit the murder. Again, the state would need then to prove more than just a conversation occurred, because the theory here is that he couldn't have known these other facts but for this conversation. And that's not the end of the inquiry. There's all types of other ways brought to light. So I think that the relevance and significance of the argument to begin with is somewhat limited as far as its overall relevance. But I think the court is correct in your assessment that this does not conform with what the appellate courts want trial courts to do when it comes to a clean trial with a clean record and without muddying the waters with a trial within a trial. So despite the efforts to declare this as panoramic evidence, I don't think it is. I think it is definitely other acts. And I think that the state's failure to actually, and it's interesting because I think I heard the term cornerstone of the case being used here. And if that were so, and if that's truly what the state had anticipated, the massive significance of this to be, then clearly there should have been a motion so that it can be litigated not on day 8 of a homicide trial, but beforehand. I also believe that, and I'll let Attorney Mueller speak on this, there was a specific motion in limine on this.
One attorney.
Yes, sir. Okay.
On a subject. Go ahead.
Okay. There was a motion in limine that was filed on this matter that I believe did directly address this this aspect of it, and the state raised no issue of intending to get into this in any way. I want to talk about some of the cases.
Oh no! Did you hear that?
were cited here. And I would
It
point
was
out
supposed
that
to be a
the Dukes
surprise.
case that the state relies upon does not address this concept of bolstering of credibility directly. The Dorsey case that talks about witness credibility is actually incorporating cite to another case called State versus Menez, which is 331 Wisconsin 2nd, 568, Wisconsin Supreme Court, 2011 or 12, I believe, 11. That case, again, was a sexual assault case where the witness that
Oh my
we're
God, I'm
talking
so
about
sorry.
bolstering the
I thought it was
credibility
off.
of was the victim of the crime. Again, it's a completely different type of analysis. So I think, to make a long story short here, we have a notice issue. We have the fact that I think there are some proof problems. The fact that the state is trying to portray this as, you know, two legs on the stool argument, again, is anticipating quite a bit as it relates to what those credibility attacks will be. But that issue should also have required an other acts analysis. So we're getting a preview of the fact that we're going to have that issue with the defendant's daughter as well. So, you know, I know that the court's very concerned about issues that don't stick to the point, issues that don't relate to what we're really here all about. And the fact that this is a distraction, it leads into other areas. The relevance that's being purported here is absolutely minimal, and it's an improper attempt to, again, in this context, to try and bolster this witness's credibility, who's not a victim of anything. Now, there are the cases that talk about the credibility of, let's say, a co-defendant or something else that is where there's a question with regard to that person's, you know, participation in the crime in question, where, again, and then we sometimes fall back on traditional methods of quote-unquote bolstering credibility, like prior consistent statements or timing of reporting and those types of things, completely absent in this situation. So this is clearly not something that should be permitted, and we object.
Thank you. Did you wish to respond?
Oh, very briefly. So the cases I cited, Judge, draw absolutely no distinction between a victim and a witness. And in fact, a victim, as the court often says it here, is a complaining witness and has to be dealt with by law as a witness. So none of these cases draw a separate distinction saying a victim gets a different kind of break in terms of this. None of the cases I've spoken about specifically rely on any kind of special statutory extra considerations for sexual assault. And I did mention the South Dakota complaint, and I apologize, I was not complete enough about the details.
Stupid
so that
smart
was a
person.
September 26, 19 South Dakota arrest, and the amount of marijuana the defendant transported and entered a plea to and was awaiting sentencing that was going to occur on May 27th, I believe 10 days after we alleged the homicide, was 26 pounds of marijuana. Thank you.
26
Thank you.
pounds? Really? And your
Well,
witness had 600 pounds?
There are a number of observations. Well, commenting first of all on the source of the information that this witness might have, I do think you're skipping some steps in there when you say, well, he couldn't have found out any other way. Well, there's no evidence of that. It's certainly possible, and there are cases that I've heard that
Now I lost it.
there have been very, very peculiar details about a particular homicide, for example, that the police don't give out to the press or to the general public, that they use later in screening out people who are making false confessions and the like, that they feel can be used to verify the truthfulness of what is being told to them. But even those, I've often wondered, how can you be so sure? you can walk around this building and you can pick up all kinds of things you have no business knowing from well-intended people. And you're the district attorney. I mean, anybody should be able to walk up to you and tell you anything.
And they certainly have.
But I mean, I don't think it's limited to people just coming to you. I think that there are people who tell me things that are none of my business. And, but anyway, to me, when I hear the term panorama, I'm familiar with it. I've admitted plenty of that evidence in other cases over the years. I'm thinking of panorama of the case that's before the jury. I'm not saying panoramic evidence cannot include something that is more of a satellite from the incident that brings the charges, but I do think of it as generally filling out the panorama of what's being tried. I often state, and probably did in this case in my voir dire, that the objective that we seek through the trial process is to put the jury back at the scene of the incident and have them make their determinations based upon the fullest possible knowledge. And sometimes that involves letting in panoramic evidence. But on the other hand, when the term panorama becomes an excuse to further push out the borders of what exceptions there are to the general rule blocking evidence, character evidence, there's been a steady growth. There has been a steady growth, and it's been commented on by the appellate courts, usually in affirming it. But you know, it is a problem that we need to be watchful about. I do think this is other crimes, wrongs, and acts evidence. And in this instance, one of the reasons that I make this statement is that the incident that you want this man to talk about right now is completely, totally, and absolutely irrelevant to the story of what happened with respect to Mr. Gutierrez on the day of his disappearance. It is relevant only.
You just said on the day of his disappearance.
On whether it, well, the definition of relevance is something that.
Is that of any significance that the judge just said on the date of his disappearance versus what the defendant is here on trial for? Question mark.
Makes more or less probable what the evidence would be without it. I'm not quoting it well,
including the credibility of witnesses.
Yeah, well, you're quite right.
This fits the definition of relevance.
Okay, so
I don't mean to argue with the
well,
court.
no, that's if
stupid smart person. Okay, so I'm gonna start doing my golf commentary. You know, the golf, like you know, they're like calling what's happening on the field, and they talk very softly. I'm gonna have to come up with something for that. He's exhibiting his stupid smart person behavior. Now, another thing I just noticed is, you know, what if, for example, the defense table just happened to chime in with that little interruptance to the judge? Do you think there'd be giggles? I don't think so. Golf claps. Oh, we used to do that when I was a kid. What was it? Round of applause. And we'd clap in a circle for a round of applause. And then we'd do seal of approval. Arf, arf, arf. Like we were a seal up on one of those like little riser things. I don't know. We were stupid teenagers. Kids.
If I make a preliminary determination that
golf clap sounds. Adding it to the list, Becca Lynn. Adding it to the list.
Agreed.
The fact that these
I just added.
sitting in the jail.
I just added
would
Judas
talk about
Priest
baseball scores,
breaking the
or
law.
football, or
Because I
women,
heard somebody say it.
or alcohol, or whatever.
Goodness.
That's harmless, no problem.
Good night,
But you could
Ashley.
bond
Thank you
over all
for
kinds of
joining
things.
us.
They could bond over, he looks honest. People saying things like that, he looks honest to me, he had an honest face. But when the, as I say, I said a bit ago, when the price becomes
Oh, I just copied that.
admitting evidence of other activity, which, though tolerated and even embraced by tax-seeking politicians, it doesn't seem to me to bolster the witness's credibility. And the price it's coming at is to accuse this man of a crime.
So
That he is totally unrelated to that for which he's on trial now.
So I understand that the court is denying my motion
Do
to
you?
admit as to them swapping stories about their drug transactions.
You are using the exact term I looked up yesterday.
Okay.
Very perceptive.
But I want to be sure I understand the court's ruling fully because I'm going to instruct him. So what about him talking about what the defendant told him about the police raid of his home, where there's already evidence before a jury? They've already seen the pictures of what was in the police raid.
I don't know what he told him.
What?
I don't know what he told him. Maybe he said,
Well, I'll make an offer
I
to the court.
had 50 pounds of heroin in the back room the police never got, you know?
Here's an offer of proof as to what I believe he'll say because it's been disclosed, right? He says when the police raided his house, he says the defendant reported to him they got a bunch of money and a little weed. Okay, so again, this is already in evidence. The jury's already heard about that. So I'm asking permission for him to be able to answer that question, and because it has to do with drugs. So I don't want to break the court's rule. But from my perspective, that's a different piece of evidence, right? It's already been heard by the jury. What?
I think that's true.
Okay, so now I understand. Thank you.
Well, that wasn't the imprimatur.
I apologize.
Imprimatur,
that sounds healthy.
ecclesiastical approval of the let it be published. It translates as let it be published in the
Even better,
Catholic
Becca
Church,
Lynn. Beavis and Butthead. That's even better. Thank you. I'm gonna switch it.
Bishop's permission for something on the subject of religion to be published because it's not contrary to Catholic teaching.
Does Gravy's
That's a long
kind of look like
explanation.
what's the blonde Beavis and
Mr. Washington
Butthead?
is here. I need to instruct him
Is
very
Beavis
briefly.
the
This will take me
blonde
a
or
minute,
Butthead the blonde?
That he is not to bring up anything about their mutual
Does he
discussions
kind of look
about
like
drug
Gravely, the
activity.
blonde one?
If the court permits, he'll be limited to the question I just asked, which is what, if anything, did the defendant tell you about the police searching his home? Period.
I'll hear you briefly on that.
The admissibility of that evidence when it did occur before that's related to that search was admitted for a limited purpose, and that had to do with impeachment of another witness. That doesn't mean it gets to be used for bolstering purposes at a later point.
Bolster.
But we have the same issue here in terms of that is all information that is contained in the criminal complaint for the Ozaki County case, which is natural that Mr. Anderson would have had. But before we go too far and have the same issue again, I'd inquire of the court if your ruling as it relates to this discussion with Mr. Washington about the drug activity also applies to the discussion or knowledge that the defendant's daughter has about the same issue, because it will come up again, and I don't believe the court has specifically ruled on that.
You're correct.
Oh my God.
I guess I'm back at the same point. The fact that the defendant may have imparted some historical information in his discussions with Mr. Washington. I don't know that somehow is, especially information that be already known to the police authorities. doesn't really constitute the defendant entrusting to Mr. Washington the innermost secrets of his heart.
Isn't it a valid argument for the state to say that this is something that is information that is confirmed by the rest of the evidence that the jury has heard? So just as each of the things that Mr. Washington says about other specifics about this case or this investigation, to the extent that they can be verified by evidence the jury has independently heard, doesn't that make them more likely to have been said by the defendant? Of course, you can counter that. You can say, well, you could get that from another source. That's, again, a valid response. But it isn't a disqualifying response. It is argument that is a valid and appropriate argument. Again, Judge, we're now talking about whether he can be questioned about something that is already in evidence in this case.
Yeah, I think that's the bottom line. You're correct. It is not in evidence for the purpose that it now is being sought, but it's not going to suddenly astound the jurors to hear this. And if for that very reason its prejudicial impact is diminished, and that is one of the factors for the court to consider. So on this, I'm going to say okay.
Okay, so I just need to briefly let him know, and then I'm ready.
Have him come over if he isn't here.
He's here. I'll just go briefly.
Okay, you can go talk to him.
What about the Olivia issue? I'm sorry.
We'll cross that bridge.
Okay.
Not names.
And hey, avoid names with respect
Yes.
to minors.
So, you know how sometimes people bring up a word like shenanigans? So for those of you who know, my real name is Shannon. And oftentimes, shenanigans is just kind of like a endearing name. So, I just so happen to have several of these in various forms. If I can open it.
Washington brought that'd
probably be helpful. Yeah.
Shenanigans. I'm gonna have to figure out where to cleverly stick it behind me. Or maybe put it on a sign. You know those like gel cling things? I think I actually have. Like, have you ever bought those old barn windows? And then like you can put chalk paint on it, use it as a chalkboard. You can like stick pictures behind it, use it as like a picture frame. I think I have one of those that the kids used to put pictures in. Maybe I'll put shenanigans in the window. All right, here we go. Are we all still hanging in there? It's only 7:12 p.m. Central Standard Time. Apparently Law Kong's clock doesn't display Central Standard Time. So for you, sir, it's 8:12 p.m. Kayla is back. Hello, Kayla. Welcome back. Can you please disclose what you had for supper? Kayla. I made Swedish meatballs for lunch with lingonberry jam.
Would you come down, please?
Yes.
Thank you.
And for the record, my sweet and sour sauce I tried to make last night, even after trying to fix it, ended up not being good. Had to get thrown away. Meanwhile, the police are pressuring witnesses not to appear for the defense. Huh. Noted. Lakung Express. So while this witness is getting ready to resume testimony, let's go over Gravely's tell signs. If I have missed any, please remind me. He does the self-hug. He pretends to be stupid. He's one of those stupid smart people. Oh, I'm sorry, I didn't know. As Dan Bongino calls it,
What's going on here?
the most dangerous that walk amongst us. He aggressively drinks his water. And he's got the chicken arm. Which, okay, so for those of you who have gone to weddings, there's the chicken dance. I might need to add that to the sound list, you know, for him when he does the chicken dance. What's happening? Oh, do we have a Hella raid? Hello, Hella raid. Hello, Hella.
You may be seated. Good morning, everyone. A word about tomorrow. We're following the weather situation.
Is this the part where a recovery addict is heard live in a courtroom? I don't know, but we saw the orange fall out of the judge's robe, although it was his bag.
Weather forecasters
Well,
have
hello and welcome. Excited utterance.
predicted 45 of the last 3-4 storms, snowstorms.
Hella, thank you so much.
So they tend to overpredict because they don't want to get burned. And that's, I don't know what's
Well,
going to do
good. I'm
tomorrow.
glad they rated it when my
we're looking at the situation.
internet
One of the things that
is being stabilized.
we're thinking about is
Welcome, everyone.
having a call-in or
Good day,
call-out,
mates.
one way or another, having telephonic contact with you.
Oh, look at all this. Oh, how nice.
Around 7, maybe 8 in the morning tomorrow to tell you whether we're going to be in session.
Okay, let's pause for a moment and let's show the Hella crowd. A Hella inspired. A Hella excited utterance inspired stinger. There you go. Thank you, Hella, for the inspiration. Oh, funny. Okay, I'm not gonna lie. I might have watched that like a few times and laughed each time I watched it. Okay, here, let's go.
And I would tell you that
Should we do it again just in case anybody missed it? Okay, now if I could just figure out how to get it to slide over what we're watching and then go off because the background is transparent. My son tried to explain it to me, and I think I know what he was trying to describe because I mean that's the way it's supposed to go. It's supposed to just slide over the paused screen, but so for those of you coming from EU's live stream, you actually came in at the perfect moment because the first hour of day 6 has been mostly Gravely and the judge with a little bit of the defense sprinkled in, and it's now we're back to the prison snitch.
it would be unlikely that court would not be held if there's less than about 3 or 4 inches of snow, unless it's blizzard and the roads are
I gotta
severely
add her to the
impacted.
bottom of the thing.
So we would generally press ahead, but we have to be realistic about the possibility that there'll be a problem. So is that a situation that wouldn't work for anyone? That if we, either by your calling in here or you being called from here, we let you know whether you should come in tomorrow or not? Anybody have any thoughts on that? Or a better way? Well, think about it, and we'll talk about it later as we get more updates on the weather. Go ahead, Mr. Gravely.
Mr. Washington, when last we were in court, I asked you a question about what, if anything, that the defendant told you about a police search of his house involved in the investigation.
Okay.
What, if anything, did he tell you about a search of his home?
Well, he told me that you guys had raided his house or whatever, and that you had found a nice amount of money and a little bit of weed.
And what did he tell you about? What, if anything, did the defendant tell you about where his house was, and did he describe his house to you in some way?
He told me that he lived in Mequon and that he owned his house. He said it wasn't big as everybody else's house, just a small little house, but he owned it.
Okay. Was there a time when you were observing the defendant when it appeared to you he was having a nightmare?
Yes.
And what do you remember about that incident?
I remember I was laying there the night before. I told him about it the next day, but I was laying there and I was reading my book and I heard him shout in his sleep before he woke himself up.
Oh.
And what did he shout that you heard?
He said, "Die, die, die, motherfucker."
And you're quoting as best you remember?
Yes.
All right. And so did you ever have a
Pause.
discussion with the defendant about this night?
Pause. Doesn't it look like, well, for starters, as I've mentioned before, if I was a defendant in a case like this, I would just probably be jailed for being out of line or have one of those like shock collars put on my face. But doesn't it look like he kind of says what?
Die, die, motherfucker.
And you're quoting as best you remember?
Yes.
All right. And so did you ever have a discussion with the defendant about this nightmare
Oh, wait,
that you
wait,
heard him
wait.
have, or these words he said?
Yes, I did.
Pause. Gravely mouthing.
Okay. Was there a time when you were observing the defendant?
Chicken
when,
arm.
It appeared to you he was having a nightmare.
Yes.
And what do you remember about that incident?
I remember I was laying there the night before. I told him about it the next day, but I was laying there and I was reading my book and I heard him shout in his sleep before he woke himself up.
And what did he shout that you heard?
He said, "Die, die, die, motherfucker."
And you're quoting?
Out in his sleep before he woke himself up.
You probably all seen this.
And what did he shout that you heard?
He said, "Die, die, die,
What?
motherfucker."
And you're quoting as best you remember?
Okay, remember what I told you? I forget now the witnesses. They're all starting to blur together. Remember what I told you? No. It was Michael's testimony yesterday. Michael was like the last half of what his testimony was. He was talking kind of like this, like he was reading off of a memorized note card, for example. I don't know, kind of the ones that like Gravely uses. You know, when you're a kid and like you read, what is the square root of such and such number? And then you say to yourself and you flip it over. Okay, just observation. But, and I had said something, it's almost like they have a script. Well, if that doesn't make you kind of question that theory, I don't know what will.
Yes.
All right. And so did you ever have a discussion with the defendant about this nightmare that you heard him have, or these words?
Okay, for those of you who are attorneys or in law enforcement who may be watching, can you explain to me how that isn't like grounds for some type of, I don't know, sanction or mistrial, perhaps?
He said.
Yes, I did.
Okay, and so if you know about how long after that happened, did you bring it up to him?
I brought it up to him the next day.
Okay, and what did you say to him about it?
I pretty much told him, I asked him about the situation about that he was locked up about, And I told him that he was talking in his sleep, or yelling about some stuff in his sleep, and he was like, well, what did I say? And I pretty much told him what he said, and he's like, yeah, you serious? And I'm like, yeah, you said it. So I asked him a question. I'm like, did you do it? Like, what, you know what I'm saying? I think you did it. And we went from there.
And so what did the
Okay, I
defendant
have
respond
heard
when you said,
I
think
have
you
heard
did it
that
based
clip
on the
before,
nightmare?
but
What
I've
did he
never
say?
seen it.
I told him to look me in my eyes and tell me that you didn't do it. And he jumped down from the bed and he looked me in my eyes and he said, I did it. He said, that's the reason I have the nightmares. I'm unable to sleep at night because I think about it all the time.
Was there a discussion at some point where the defendant said to you, is it that obvious?
Yes, he did.
And so when did that come up?
Objection leading.
Was the limb pinch they gave to the court on their own? Okay, so Feral Housewife. The other day I noticed that Zachariah, I think one of the live streams that Soloman was on, I think I've mentioned it a couple times, but I remember mentioning it when he was here. Might have been yesterday. But I noticed a few days ago, Zachariah, like when he's sitting there, he kind of does this as like almost kind of like a, like a thinking, you're not aware that you're doing it thing. And that, did that get taken out of context? And I thought that was interesting. And then someone in the chat said the court report, I think the court reporter, someone in the court, some woman in the court had brought it up. But I remember, because I didn't watch this trial live because I was setting up Crime Spies and starting Letitia Stouck. But I remember that clip of him with the pinch and the daughter's testimony and how that was, he's trying to silence his own daughter from speaking the truth. I remember thinking, boy, that's not good. This is just so wrong.
When, if ever, did the defendant say to you?
I'm going to rewind that part. I'm so sorry.
And he looked me in.
He say?
I told him to look me in my eyes and tell me that you didn't do it. And he jumped down from the bed and he looked me in my eyes and he said, I did it.
With a bad back, he's supposed to be able to jump off the top bunk.
He said, that's the reason I have the nightmares. I'm unable to sleep at night because I think about it all the time.
I think this was in either the podcast.
Was there a discussion at some point where the defendant said to you, is it that obvious?
Yes, he did.
And so when did that come up?
Objection leading. The very definition of leading.
Rephrase your question.
Wasn't this in episode 4 of the podcast? Or perhaps Law Kong, one of his awesome videos? Well, John Gary, you do have a point there. I mean, Gravely does tend to, mouth the words. Or I don't know what he does.
When, if ever, did the defendant say to you, is it that obvious?
Objection. The exact same question.
A tell.
That taught in some law schools that's not a leading question. Others, like the one I attended, say it is. So it's not firmly settled, but I do think in the final analysis, it tends to suggest an answer, so the objection is sustained.
In the discussion that you had where he looked you in the eye and said he did it, what else did he say, meaning the defendant?
Well, after we had talked and I told him, I basically knew he had did it, because I've been around killers. I know killers, like, pretty much, and he seems like a killer. I pretty much asked him, like, how did you do it?
Judge, I'm going to object here.
So let me get this straight. This is all proceeding in front of the jury, correct? So even if some of these objections from the defense are sustained, you can't unring a bell.
He has no way of knowing who's a killer and who isn't,
Right.
other than where he has personal knowledge,
What's up, man?
such as something he would have observed with his own senses. And then there's
Bye,
people
Feral
who might make that
Housewife.
statement based upon
Let's make sure to remember the
hearsay that we
cookbook.
talk about all the time, and that's not even been stated here. So he's making a judgment just based upon no basis at all, really, in fact, that would ever be considered admissible in a court. So please disregard that entire statement. Any question?
Disregard
you.
that entire
So when you
statement.
ask the defendant,
Disregard that entire statement. Sorry, this is really important. Disregard. Okay, I'm making a note. Okay, continue.
how did he do it? What was said next? What did the defendant tell you?
Well, he spoke indirectly. Starting off, he wasn't pretty much trying to say everything that he did. I felt like he was held back, but he said that, well, if you gotta know a person, you gotta learn a person, you gotta be able to know, where they live, how they move when they leave, what they drive. And then he told me, one way of knowing when a person is gonna be a certain area is GPS tracking. And he told me Amazon sold GPS tracking that you can put on people's car.
Did he use a phrase to describe the circumstances of his case?
What do you mean?
Did he, at some point were you aware of a nickname that some people had given the defendant?
Yes.
And at some point, what nickname did you hear people address the defendant with occasionally?
A lot of times people would say Houdini or Zach Houdini, or just telling me about who my cellie was.
And and was this a nickname that you did you understand why this nickname was given to the defendant?
Yes, I did.
Why was it?
Objection.
What's the relevance?
What
of
on
this
earth is the
nickname?
basis?
Because of what the defendant's reaction is to the nickname. So my offer of proof is when the defendant
Wait,
was...
no, Judge.
Well, no, he's talking.
No, but I think...
He's talking.
Okay.
When the defendant was confronted with this
Again, doesn't it seem like if the attorneys were reversed and it was Mr. Gravely getting shushed by the judge? I mean, I would still consider it bias. This is just... I don't know. I don't know what's going on here.
nickname, he, according to the
Well,
witness, there was a
well-
reaction that is relevant.
Judge, I think that we had, in fact, the court instructed us to not go into all of this
Well,
arguing about evidence in front of the jury.
Keep in mind, people, all of this, the last, what, 10 minutes
I think
has been, well, since
the
the
last question
EU
was
raid has
oh,
been
started with
in
the
front of the
why?
jury.
as a word.
I didn't know
why?
that either. Becca Lynn says,
Pardon me?
Stray, I wish I could... Stray, I'm sorry, I have a squirrel problem in the evening. Stray says, I wish I could bring baked goods for everyone, but they haven't invented how to share those live chat yet. I feel badly. Okay, never feel badly. This is a community of in my berry, well, no, I can't do berry white. Love. So, never feel badly. Number 2, I'm pretty sure there were 3 donuts involved with my evening routine last night because I was so hungry. Okay. And I was upset that my sweet and sour sauce didn't turn out. So I may or may not have
Why
had
don't you start with a
3
new
donuts.
question?
When the defendant was called Houdini by individuals, how did the defendant react?
He never denied it. He just would laugh it off or, just go on about his day.
And did the defendant talk about why people were calling him Houdini and describe, what that was about to you?
Yes, he said they called him Houdini because of his case, basically because he made a body disappear, they say, and everybody called him Houdini because of it.
And what can you say about how he was acting when he described that to you? Was he sad, regretful, just neutral? Was he proud? Describe his reaction as he had that discussion with you.
I think he was kind of like proud, but not really showing it. Like he kind of smiled it off. I mean, in jail, like you, when you're around people, you got to have like this kind of name for yourself. I don't know. Everybody fighting the same battle in there, so everybody fighting different cases, and he kind of like know his case is big, and because of it, everybody know him. So he kind of like wear that jacket a little bit. He doesn't admit it to everybody, but he does wear the jacket, in my opinion.
Okay. And what, if anything, did the defendant tell you about the circumstances on how he committed the crime? So you've already talked about, he said it took a lot of work. You got to follow the person's patterns, trackers from Amazon. You said all that. So what did he tell you ultimately? Were any of the circumstances he told you about how he did anything?
Yeah, he ultimately pretty much just told me that.
Well, I don't want to hear testimony of. He pretty much just told
Okay.
me.
Well,
I'm not scolding you. I'm just
Okay.
telling you. You can quote exactly what was said.
Oh, there
but
she is.
We don't want your
pretty much.
conclusion pretty much told. Okay?
Okay.
And Judge, a witness is not going to be able to exactly quote. We're not computers, so he's going to say, here's what I believe I was told, right?
Well,
I missed my cue. I'm
know,
sorry.
I understand. Your point is legitimate.
Okay, so
However, that's a flashing warning sign when someone states he pretty much said thus and so. You may be able to access the information you seek with a different question, but we're 9 days into this trial.
Yeah.
We don't want to ignore flashing warning signs.
okay. So what did the defendant tell you about how he committed the case that he's charged with, and what the circumstances were?
He said that he had seen this person, and he said he stabbed him, and he blacked out. He said he stabbed him, and I just blacked out. And he said he eventually wrapped the body up in garbage bags and got rid of the trash. He threw the trash out.
Okay.
And I asked him, what did he mean by that? And I said, what, like dumpster or trash? And he said, once it's gone, it's gone.
It's probably why Sadie called 911 an hour after the garbage was picked up.
What if anything, did the defendant say about whether after
Snitchy.
killing this person? Well, all right. So based on what you've said, putting in trash bags, it won't be found. Did you ask him any follow-up questions about things like how he moved the body?
Yes.
Okay. And what did the defendant tell you about how he moved the body of this person?
Well, I asked him, like, cause I'm like, you did this by yourself, pretty much. Well, you did this by yourself, and he said yes. He said he took him on his own. He didn't have his help with his brothers, because you guys said that his brothers was involved with this. He said he did not have any help. He did it all by himself. And I'm looking at him like, okay, don't look, I don't know if he was telling me the truth or not, because he was not a big guy, but he said, you should have seen me before I came in here. He was like, I was real cut, I was healthy, I was strong. You know, when I first came in here, everybody
they
was
just
calling me
letting him-
Superman. So I'm like, oh.
And did he say, other than his own strength, did he say any other reason why he felt like he'd been able to do it himself?
Other than strength and adrenaline, that's everything he said.
Now, did you ask him, or I'm sorry, what if anything came up about why he did this? Why would he end this person's life?
He said to get back at his kid's mother.
And what did he tell you any more about that?
Yeah, he said that you know, he was angry with a bunch of different things, but he said she kind of bragged about this other guy and that she was happy. He didn't really want his kids around that.
Other than the details you've described so far, did he provide any other details to you about the offense or any other of the circumstances of this case, other than what you've said so far?
He didn't really speak much. He told me what he told me, but he did say, no case, body, no case, and that was...
Briefed by the government.
All right, I'm going to do my daily summonsing of the body language guy, Jesus Enrique Rosas. We could really use your assistance when he said something to the effect of no body or whatever that was. I don't know where we are in the transcript because I'm eating pistachios and reading the chat. But she looked and then she tilted her head back and did a like, was that a acknowledgement that we have succeeded? They have not found it yet. Or, and then she did a little look over to Zachariah. I guess I'm just saying it would be helpful to have an actual body language expert. If you don't know who he is, he's like Portuguese. He lives in London. And he's amusing, yet very knowledgeable.
Were you asked about whether you knew of any other crimes?
Yes.
Part of that? Okay. And that was originally when you talked to authorities?
I thought about it, but I did not.
Okay, so can you describe to the jury why, if you had already been confessed to by the defendant, why, when you were debriefed in 2022, you didn't choose to share this with anybody, any authorities?
Initially, I didn't know if me being federal, that would be something that I could use, and then I also didn't want to deal with everything that came with it, like being...
What do you mean by that?
Like being put out in the open, like over the news, all over the media, you know, that comes with risk factors. That's a lot of stuff that I wasn't really know if I was ready to deal with.
So, best you remember, had you told anyone about what the defendant had told you up until just a few months ago?
No.
Okay. So, do you have an attorney in your case?
Yes, sir.
And who's the first person that you decided finally to share this information with? Who'd you tell first, hey, I know some facts about what Zachariah Anderson did?
My lawyer.
Okay. And did you, and what were your instructions to that person? So when you told them, did you ask that person, hey, tell somebody this, or what happened?
I talked to him about, because like I said before, he asked me, you know, what all did I know at this time, like, are you sure you don't know anything else? And I pondered about bringing it up again, and I brought it up to him. I was like, well, I do know something, and he said he was going to look into it, and he got back to me, and he told me you really should speak up about it.
And after hearing that from your lawyer, did you, what decision did you make?
I spoke up about it.
during the time that you roomed with the defendant, describe his sleeping habits if you can.
He barely sleeps. That was one of the reasons we.
Excuse me, but has this witness been qualified as an expert on sleep? Sleep expert? Question mark. Hi, Lynn. How are you? Actually, this is day 8, the first hour of, well, the last hour of day 7, roughly, and the first hour of this day 8, where the attorney's arguing. So at least
Able to get along. I mean, we both had different schedules. Well, he didn't sleep really at all.
Objection, relevance.
isn't that kind of what I said?
was-
Like, I mean, he's not an expert.
Goes to the discussion of the nightmares that he had, and is a part of the discussion where.
Overruled.
Go ahead.
Overruled.
Yeah, well, he barely
sorry, I
sleeps, like
shouted.
I say. Before I got in the room with Zach, he had told me from the dribble, like, dude, if you snore or anything, I can't be sealed up with you. I'm either go to the hole or you gonna go to the hole, because I barely sleep at night, and when I do sleep, I like to stay asleep. And I'm like, okay, so being in the cell with him, it worked out fine. That's why we was pretty much good cellies, because I stay up all night. And
think
he
his
stays
pants
up
are
all night, so he
smoldering.
goes to sleep first. By the time he falls asleep or drift off for a little bit, I fall to sleep too, and it's pretty much breakfast after that.
Somebody who is really good at, like,
I have no further questions.
Cross-examine?
oh, of course you don't, Mr. Chicken Wing. Mr. Stupid Smart Person. This is the worst gong show. Ooh. I really need some help.
As you
With-
wish.
Did he just say as you wish? A quote from the best movie ever, Princess Bride?
Show this counsel to us before.
I need to add more videos. Inconceivable. This whole trial is inconceivable. It is inconceivable that this was even brought to trial. We actually, Peace Peony, we were discussing Princess Bride earlier. Inconceivable, rodents of unusual size, pirates, sword fights.
Yes. So,
A mostly dead mouse that my girls brought home one day from on their way home from the bus
thank you,
stop.
Judge.
Planet of the Pause. I'm getting punchy. Lot Kong Express. How dare you? How dare you? Oh my gosh, we need that too, Greta. How dare you? Planet of the Apes is the best movie ever. I challenge you to a battle of wits, my friend. Remember that from Princess Bride? Or maybe not. Okay, now full disclosure, Planet of the Apes, I think, was a TV show when I was a kid and a movie, and it kind of scared me. I'm not going to lie. Someone said, marriage. Marriage is what brings us together today. Oh my God, that's so funny. What do we... Okay, so for those of you who are on who are on YouTube, this is why it's so fun to do some of these like movie watches, documentary watches over on the Rumbles and the Kicks, because we could actually watch Princess Bride together. We could do that on New Year's Eve or something. Planet of the Apes was 4 movies and I think a TV show. I'm pretty sure it was on my TV when I was a kid. It did scare me. They were very lifelike, let's just say. That is so funny. You guys are funny. Continue. Let's continue.
No.
Okay. I just remembered I have another plant. He's an English ivy. His name is Wesley. Get it? English ivy. Wesley from Princess Bride. Actually, I think Wesley is dead. Maybe he's mostly dead. Because I made the mistake of putting him outside. I think I left him outside too long. I don't know. I'll have to check. We've had a very mild winter so far. Mostly dead. Oh my God, that's a straight. Andre the Giant was Lily's favorite because she would always do the inconceivable, and she found that Andre the Giant was very endearing at age 6, and she's 17 now, and she still loves Andre the Giant. Actually, Carrie Elwes, I don't know if I ever pronounced his last name right, but he tells this story. I have the Princess Bride book that he wrote like 8 years ago called As You Wish. And if you go on YouTube, he does like screeners of the movie locally in smaller theaters. He was just here in Minneapolis like over the summer. And then they watch the movie together, and then he does question and answer and signs books. I wanted to take the kids because I like noticed it 2 days maybe before he was going to be here, and they had tickets, but there was like one ticket way over here and one ticket way over there and one ticket way over there, and it's a super tiny theater. Anyway, so I'm gonna have to keep an eye on that because he's been doing that I think for a few years. But if you go on YouTube, there are some. My thought here, the scene where he falls down the hill and he goes "As you wish." That scene. Apparently, Andre the Giant had a 4-wheeler because he was so huge, and I can't remember if they filmed that in Canada or where they filmed it. Maybe it was in Europe somewhere. And so Andre the Giant came up to him and said, "Hey, boss, want to go for a ride?" And somehow or another, Carrie, the guy that played Wesley, the blonde one, broke his foot. And then he was too afraid to tell Rob Reiner that his foot was broken. And you'll just have to look up the scene or the clip of it. Maybe I'll try to find it. There's another one about Andre the Giant. Okay, so remember when Wesley was, after he'd gone to the witch and the wizard, and they gave him, have fun storming the castle, that part. And they're at the wall, and Andre the Giant had the cloak, and he's like starting to get like movements in his head and finger back. Well, apparently when they were filming that scene, Andre the Giant had some big giant fart, and he describes it also in a clip on YouTube somewhere. So there you have it. More rambling. More rambling squirrel stories for your.
Sounds good. Sounds good. Okay. So, Mr. Washington, I'm going to ask you some questions. If at any time you don't understand, ask me to rephrase it. Glad to do that. Okay. I'm going to ask you some questions about your current federal case and some of the interviews you gave. Okay.
Okay.
Okay. And if there's ever a time that you want to confer with either of the district attorneys before you answer, let me know.
Okay.
Okay. And maybe if you could like scooch up or pull the microphone up a little bit closer and talk right into it, because I know you're soft. All right. right? All right, so I want to start with, on October 5th, 2021, you were indicted in the Eastern District of Wisconsin, right?
Yes.
And I'm going to show you what's been marked as Defendant's Exhibit 246. Do you recognize that?
I do.
What is that?
That's my indictment.
That's the original indictment
Yes, sir.
on October 5th, 2021?
I believe so.
Okay, and that indicts you and 13 other people in a drug conspiracy, is that right?
Correct.
And the drug conspiracy is a conspiracy to distribute both, and it alleges in the complaint, in the indictment, 280 grams or more of a mixture containing crack cocaine and 5 kilograms or more of a mixture containing cocaine, right?
Yes.
But of course, as you talked about on direct, the amounts were far greater than that, right?
That's what they said, yes.
So you're into a plea agreement, which we'll talk about later, but you're going to enter into a plea agreement with the federal government, right?
Yes.
And as part of that, when they give you the plea agreement, they give you an attachment with all of the activities that you and all the co-defendants did as part of this conspiracy, right?
What they believe we did, yes.
And, well, it's what you're going to admit that you did, right?
Oh, yes.
So, because you can't enter into this plea agreement unless you admit your guilt, correct?
Correct.
All right. So, in this case, you and Brian Phillips and Gerardo Laro are accused, well, at least in the attachment to the plea agreement, of pooling money to buy kilos of cocaine, right?
Yes.
And just the three of you alone got more than 9 kilos, right?
Well, that's what they said, yes.
That's what they said. But that's what you know, right?
I didn't say I know that.
Well, you said to the district attorney on direct examination that the entire conspiracy did more than 30 kilograms of cocaine, right?
No, that was for me. That's what the drug amount they put on me.
That's just you. That's what they call relevant conduct, right?
Correct.
And that's directly attributable to you?
Correct.
Okay. And so you did that with Mr. Phillips, Mr. Laro, and others, right?
Yeah.
And you did that in the context of being a a gangster disciple, a gang, a street gang, right?
That's what they say, but we're not gang members, no. But yes, you could say.
Well,
whatever the paperwork says, yeah.
the paperwork says that, so you're going
Wait,
to have
is
to...
he gonna say it's a family like Bryce Rhodes
Who's your
did?
attorney?
No.
Matt Ritchie.
No.
He's not here?
No, Mr. Ritchie is aware that he's testifying, and
I misspoke. The dentist, Charlie Adelson trial. The gang members were not a gang, they were family. Just wanted to clear that up in case you were wondering.
is supportive of his testifying in this case.
Has the agreement with the United States been signed?
No.
Not a signed agreement, but not only has the U.S. Attorney
Remind me again if
approved
this is in
this
front
testimony,
of
but so has his lawyer.
or outside of the presence of the jury?
But it hasn't gone to judgment yet.
Correct? No.
The attorney's aware he's testifying.
Yeah. I spoke to him yesterday
Not
morning.
just about what he allegedly heard from the accused, but also as to his own alleged criminal misconduct.
Well, I mean, he's aware if you testify in a case like this that there will be questions asked to you about. I mean, this is a attorney who has entered a federal agreement with him and was the one who coordinated his testifying with us.
In front of the, oh my God.
Some of the questions you're being asked relate to your own personal conduct that could expose you to criminal prosecution. and statements that you make can be used as evidence against you. Do you understand that?
Yes, sir.
You've got a pending case right now. It's not gone to judgment. It's not been resolved. You haven't entered a plea. You have an agreement to enter a plea, but until the judge accepts it, it's not going to, it's still a pending case. So you have the right to talk with your lawyer about any question that seeks information about your own personal conduct. Do you understand that?
Yes, sir.
All you have to do is tell me you want to talk to your lawyer and you will be permitted to do so. You understand?
Yes, sir.
Any question about this?
No, sir.
All right. But
Thank you, Judge.
So I'm going to object to the question of
course.
gang membership. I don't know why that would be relevant to this inquiry.
It will become relevant.
go ahead.
Thank you. So the three of you were involved in conspiracy. Well, there was others too, like 13 total, right?
Yes.
And you shared an apartment, right?
That's what they said, but no.
You didn't share an apartment.
No.
Okay. To store, well, you stored your money and your drugs in an apartment, right?
It was an apartment that we all frequented, but
Right.
and we used from time to time because we dealt with the same people.
Yeah, I wasn't saying you lived there. You shared it to use it for drugs and money, right?
Yes.
And you also shared the same supplier, right?
Yes.
And you engaged in fronting drugs to other individuals to sell, right?
Yes.
And you also pooled your individual money to buy drugs, right?
I didn't do that, but people on the case did, yes.
But other folks in the case did?
Yes.
And you were kind of the head of the whole operation, right?
No.
No? Okay. So you would also service each other's customers, right?
Yes.
Service
So
each
you would
other's
share drug
customers.
supplies and drug packaging, and is that right?
Yes.
And you would also share rental cars in order to service drug sales, right?
Well, that's what they said, but I didn't do that, no.
You didn't do that.
No.
Okay. So, and most importantly, you
Definitely,
were
I'm starting to see
the whole thing was
flames.
designed for you to protect each
Smoke
other from
billowing, if you
detection by
will.
law enforcement, right?
That's what they said. That was their opinion.
Well, and so let me just get this straight then. When you go to enter your plea in federal court in front of Judge Edelman, you're going to deny that.
There's a few things that I am going to fight before I sign my plea, yes.
Okay. All right. Did you talk about that with Mr. Ritchie, your lawyer?
Yes, I did.
Okay. So that was the scope of the conspiracy, but they also had, as part of this indictment, by the way, I would move to admit defendants D46.
Any objection?
No.
Identify that by
It's a,
federal description?
yep, it's an indictment.
246.
It's
Yep.
the indictment?
The indictment, right.
Okay.
There's a superseding, but that different name. So that was the scope of the conspiracy, but also you had, they had some controlled buys on everyone else that was in the conspiracy, including you, right?
Yes.
And between March 14th, 2021 and October 21st of 2021, they did multiple controlled buys with you, right?
Yes.
Totaling 38.7 grams of crack, right?
We need Detective John here. He had many, many years in drug operation sting things.
Yes.
And they did buys from the
I need to make a note and ask him if a federal charge for the large amounts of drugs this man had that he was given a plea for and the whole snitch testimony. I'd be really curious to see what he had to say about that. Continue.
from 11 other folks, right?
Yes.
This is just disgusting. Just the gross.
They also allege that you threatened one of the informants, right?
Yeah, they said I did, but that didn't happen.
And that occurred on July 10th, 2021, right?
I believe so.
Wait.
Yeah, and so that was
So, wait a minute. Jen RN says 3 charges in cocaine bust in Racine approved to receive PPP loans in 2020 2021. Those were the loans, the Rona loans for people with legitimate business operations that were interrupted during the Rona to provide relief so they can continue to pay their employees. Those loans, he got those loans for his drug operation. Okay. Oh my God. I've listened to watched quite a few subcommittee hearings where they talk about the fraud, the money. I can't remember off the top of my head how much, and it wasn't managed. And don't even get me started. Oh my
was where you and Mario Johnson were out looking
God.
for this individual because you thought he was an informant for the police, right?
That was a lie as well. We already knew he was an informant.
So for those of you that might be making some type of delicious, evening beverage or dinner or having a snack like I am, or maybe you're over in a different part of the world and you just had lunch, I want you to know that this gentleman here, who testified as a prison snitch for Zachariah Anderson while he was indicted on federal charges for 600 pounds of cocaine, 600 pounds of Mary Jane. I forget how many grams of the white lines, as Duran Duran says. And minimum 10-year federal sentence. This guy here, he's out of prison. Guess when he got out of prison? After this trial concluded.
For the police.
Okay. But you were driving around in a black truck with guns looking for him, right?
That also was a lie.
That's a lie. You're going to deny that when you go in front of Judge Edelman?
Yes.
Got it. Okay. Just want to make sure we're on the same page. All right. So this indictment in Defendant's Exhibit 246, which was filed on October 5th, 2021, you weren't arrested right away, right?
No, I was arrested, but not here.
You were arrested on October.
So he was arrested on October 20th. October 20th. This trial happened wasn't he sentenced like in early May 2023, so a year and a half later, on a 10-year federal sentence, mandatory, a year and a half. Is that all he spent behind bars?
October 20th, so 15 days later, right?
Everybody was, yes.
Right, and that was the day they did a raid on your girlfriend's house on Chicory Avenue in Racine, right?
My kid's mother house, Chicory Road, yes.
Chicory, sorry, excuse me. So, and there they arrested you and they found a backpack with $24,000 in cash, right?
They did not arrest me there, no.
They didn't arrest you there.
No.
Said $24,000 in cash. Huh. Okay.
But they found the cash.
Wait, is Soloman and Jen still in here? I think one of Soloman said, so, they confiscated the money in Zachariah's home that he had taken out a couple days prior to the victim disappearing, using the judge's own words. And, it's, if you've been listening to the Wrongful podcast on on Apple Podcast, iHeartRadio, Spotify, YouTube, etc., please make sure to use the link below to vote before the 18th Annual Podcast Awards. Remind me to go over that later. Now I forgot what I was saying. Oh, it'll come back to me. Oh, the money that Zachariah took out because they were going to like sheriff sales. If you go to a sheriff sale and you bid on a house, you better pony up the cash. Haven't you guys ever watched those like home renovation shows where they buy like a dump? They can't even get in it. The auctioneer's outside. They did that with like Storage Wars or something too. You need the cash. That's what the cash was. And then I'm pretty sure the podcast had said that it was short. So, and then I think Soloman in one of the first couple days said they never did get the money back at all. I don't know if that's true, but let me know if that's my understanding now is the money was, they never did get the high $40,000 money back. I wonder what this guy was doing with his $24,000 in a backpack.
Right?
They found heroin money, yes.
Okay. And they also found a Taurus G3C 9mm in a small dresser in the closet of the master bedroom, right?
I believe so.
Okay. And that was yours, right?
No.
No?
No.
Okay. So now, shortly thereafter,
He says
the
no, and you
original
just take
indictment
his
was
word for it.
filed
Was
on
it
October
fingerprinted?
5th. And on November 2nd, they filed what's called a superseding indictment. Is that right?
Yes.
I'm going to show you what's been marked as Defendants
I'm
247.
on mute.
What's that?
Yes, an indictment.
I'm sorry?
That is the rest of the indictment.
That's the superseding.
Okay, so for those of you who are unable to read the chat, this is very important. The question that I just had about the money that they confiscated from Zachariah Anderson's home, the money he withdrew a few days before the victim disappeared, according to the judge, $47-ish ballpark $1,000 that was used, and a habit apparently, if you look at the bank records, of activity on his account. According to the podcast, it was short. And then, according to Soloman, it was never returned. The answer is Jen RN, who's Soloman's wife. Sorry. Yes, that's correct. The police miscounted part of the money, and the feds seized the rest under civil forfeiture. That alone should infuriate you. If you added that high 40,000s to his defense fund, or his appeal fund, This is unbelievable what happens.
Indictment, the second indictment,
That is-
right?
Yes.
And
Thank you for clearing
Excuse
that
me
up,
for 1
Jen.
second. So just about a week after they raid your girlfriend's house, you said they didn't arrest you right then?
No.
When did they arrest you then?
I'm sorry to keep pausing, but this really bothers me, so I'm just going to keep going. Irish La Tejana says to John Gary, thank you again for sticking around. And yes, a Taurus. You'd think he would be able to buy a better 2A, nug. Okay, he needed his testimony because he didn't have anything on Zachariah. So that's interesting, Irish, because In the Wrongful Podcast, episode 4, our very own king of the Crime Spies chat, La Kong Express, read the part of Zachariah in episode 4, to which he said that they tried to move him, Zachariah, around different prisons in order to break him. They tried to throw him in the hole so they could toss his room and mess, steal, destroy his stuff. You're telling me that they didn't, with this guy here, they didn't try all of their little tricks? I gotta find in the John F. Kennedy book I have over there, there's a part, like several chapters, where he goes over like the things that people had done to them to manipulate them, let's just say.
They arrested me on the highway.
Because you weren't at the house when they raided it?
I didn't live there, that wasn't my home. But when they did the indictments and they came and rounded everybody up, I was on the highway, everybody else was at their homes.
Okay.
Civil forfeiture.
So in the original indictment, they charged you with...
I don't speak lawyer, but civil forfeiture, like you forfeit, I don't know how to describe it very well, but you forfeit your assets in order, is it in order to possibly pay damages in a civil suit? I don't know. I don't know what that is. Basically means they didn't get it back. The family didn't get it back. The feds took it.
The conspiracy, first I would move to admit defendants 247, the superseding indictment.
Well, subject to the question, so far there hasn't been a question.
We identified it.
He identified it.
Oh, okay.
Received.
So the
Jen Arens replies to the civil forfeiture question, which now just disappeared. Oh. Basically, if the government suspects assets to be connected to a crime, they can just steal it from you. That's true.
The original indictment alleged a conspiracy.
So if they suspected that it was in the connection to a crime, and then now he's guilty, then obviously, I mean, maybe if he was acquitted, they would have given it back. But imagine, I mean, you know, they're trying hard to raise $50,000 by the end of January. And that right there is $50,000. We're close to it.
Running from January of 2020 until October 5th, 2021, right?
I believe so.
And also one additional substantive count of you delivering crack cocaine on April 21st, 2021, right?
Yes.
We talking about the original indictment 2.6?
Yes, I'm going to compare them two. Right.
There's one of his tells.
Judge,
Mr. Interrupt.
I'm going to object to the nature of the question of comparing an indictment
You
that
lose
no longer
everything, guilty or
exists
not.
to the new one. I have no objection to getting into the new one, but why does the comparison matter in terms of this witnesses?
Well, I'm just going to...
Okay, I'm going to just pause Dinkleberry one moment. Jen RN also says, which they conveniently pretend that Zach's money was drug money, even though he had receipts withdrawing it from his own personal investment account. Huh. Interesting. I think most people... Okay. Munch had a flash drive with Zach's case on it. Huh. You would think that a flash drive... How in the world would a flash drive be allowable in a prison cell? It's my understanding, you know, they can't have a lot of things. Philip Haney, I think was his name. He's an older man, worked for the CIA, I believe. And he carried a flash drive around his neck, like as a necklace. Glenn Beck a few years ago had a clip. Glenn Beck knew him personally. And let's just say Philip Haney had a lot of secrets. That's why he wore the thing on his neck. And Glenn Beck says, the last time I talked to him, we talked about this. And, when we were saying goodbyes, I patted him on the chest, and that flash drive was there. I wonder if the flash drive, and then supposedly he self-harmed himself on the side of a road, like a month before he was supposed to get married. He was an older man, leading up to that, and it was the side of the road. And so Glenn Beck ends that little segment, the dedication to Philip Haney, with, I wonder if they found that flash drive on the body. My guess is they didn't. So how in the world did he have a flash drive in his cell, I guess is what I'm saying. And I don't know, when Zach was put into the hole, did this prison snitch and the guards, were they still in there, or was like the cell empty? Don't make me get my tinfoil hat out. I will. I wear it a lot.
Correct me if I'm wrong, that was part of the concession?
Well, no, I assume this will be, this is not announced.
I'll make it relevant, Judge.
All right.
In the next question.
All right.
Well, I'm not comfortable with, just to apologize, Judge, I'm not comfortable with assurances I'll make it relevant. That's...
Well, so...
I'm ready to pounce.
I'm well aware. I'm on notice. Thank you, Judge. So the superseding indictment then
Okay,
adds
go
a
ahead
count
and cut
for
him
you
off when
of
he's
felon
trying to make
possession
his
of a weapon,
defense.
right?
Correct.
After you let the dingleberry
And they
go
could
on and
have,
on.
if they wanted to, you're familiar with what a 924C is, right?
Yes.
So a 924C
240P.
is a federal statute that charges possession or use of a firearm in relation to a drug trafficking crime, correct?
Correct.
And you've talked about that with your lawyer, right?
Yes.
And that contains a 5-year mandatory minimum consecutive to any other case, right?
Yes.
And if it's used, or if it's drawn, it's 7 years, and if it's used, it's 10 years mandatory, right?
I believe so.
Okay. So, but they didn't charge you with the 924C. They just charged you with the felon in possession, correct?
Hold on. I'm going to object to the relevancy of this. Again, what we have right now is that this is an indictment. I believe that I have it written down as dated November 2nd, 2021. So it predates anything that has gone on in our case. It predates any contact with our case. So why would whatever the maximum charges versus what the federal government charged him, why would that be relevant to his veracity in this case, to his being?
You're welcome to go upstairs if you want, but I'm hoping this will be brief, and you can remain down here if you prefer. Don't talk about the case, please.
So the basis of my objection is I don't think it's relevant what charging decisions the federal government has made, whether they could have charged something higher and have charged something lower. That's the current inquiry. So then I don't believe it's relevant. So the machinations of the federal government before they are in a plea sort of posture from the state's perspective are irrelevant. Certainly anything that happens after we have an agreement or they have an agreement is.
So the relevance, Judge, is that he knows what a 924C is. It's a very serious offense used quite often by the federal government as a lever to get people to cooperate. And he's not currently charged with it, but that is a very, very common occurrence in federal prosecutions where if you end up going to trial, then they add it on. And they also add on something called a NA51, which doubles some of the mandatories. So a lot of that is left off the books, but everybody knows it's there.
Well, but the critical reason I'm admitting this evidence is that it bears upon any concessions which may have been extended to this witness to induce him to testify. And am I understanding you're claiming that this superseding indictment was submitted, was returned before this crime allegedly was committed?
The superseding indictment is before he ever enters any cooperation agreement. He is in no way in a cooperating posture. What we're talking about right now, the superseding indictment is
Jen RN, this, oh, wait. Our king of chat, Lockhong King, mentioned Zachariah Anderson also was a landlord to several properties. Thank you, Mr. Encyclopedia. Encyclopedia Brown. Encyclopedia Crown. There, now you have a new name. Encyclopedia Crown. And then Jen RN replied to Aaron and said, exactly, and who then would call the cops to their own home in which they are still actively burning evidence of said murder? Okay, so for those of you that were here on Christmas Day when Detective John popped in, he had mentioned the fact that it's in order to burn a body so that like teeth and bone are, I don't know what it's called, but they turned up like powder, like, you know, like cremated remains, is 1500 degrees. I forget the duration of time at that temperature, but Michael, when he testified, and I think Brandon both were asked the question, did you see any fire? And they both said no. So this is like, you know, maybe a day and a half after the victim disappeared, per the judge's own words. How long does it take for a fire to get to 1500 degrees? Number one. Number two, how long does it take to burn a body at that temperature? And number three, how long does it take for a fire of that heat to, you know, not be smoldering anymore, or the smell of smoke in the air? I mean, we have little tiny bonfires in our driveways, and you can still smell the smoke the next day.
the
And I
charging
mean,
decision made by the federal government when they are placing them in custody and beginning the process. It has nothing to do with cooperation from anybody, us or anyone else.
Well, I don't know that, and Mr. Birdsall has stated that it's not. He didn't. Well, I think he said sometimes they add these aggravating charges when you go to trial. So there's some leverage there to the federal authorities. And the question then becomes, and I don't want to get bogged down on this, whether the federal authorities are aware that the witness has information that the district attorney would desire.
At the time of this indictment, they do not. At the time
The superseding indictment?
Correct. Both of these indictments that have been talked about so far predate any information with the DA's office. Okay? Again, this is November 2nd of 2021.
Well, the filings predated.
That's when the filing, and that's when the charging decision is officially made. There has been no discussion of our case in any way, shape, or form until January of 2023.
I don't think that's what the objection was. I think the objection was that 924C wasn't alleged in there. It's just lurking out there. It's lurking as a potential hammer that hasn't been lowered yet.
But it's a
But
hammer.
if they go to trial, then oftentimes those are added.
But that could be just, I'm sure this wouldn't be stated, but it could be used as leverage just to prevent the defendant from exercising his trial right.
That's correct. That's exactly what it's used for.
It's what we do nowadays in the criminal
I know.
Feels to me like that's an inappropriate question to say you haven't been charged with something where if you exercise your right to a trial, you will get this extra piece.
Well, you're talking about what theory is or what reality is?
Reality. That how is that how does that go to his credibility? He's allowed to go to trial. So something held over his head about whether he goes to trial is not commenting on his credibility as a witness.
We're not commenting on his credibility as a witness.
Soloman, Detective John also had asked a question whether or not there was any kind of like brain matter or skull fragments at the crime scene. And again, looking at the pictures that I saw, I'm pretty sure someone very smart, either Encyclopedia Crown or one of the lovely ladies from Wrongful, or perhaps you and your lovely wife. My voice is going hoarse. Oh no. Had said no, there was no blood or brain matter. But just in looking at the crime scene pictures, I was actually kind of shocked at how much it was just like splattered all over the dining room, all over the Easter eggs and the kids' drawings, chairs, walls, ceilings. I wonder how he got the body, transported it. I mean, it wasn't in the car. Had to have been in that minivan. You would think leaving behind all that, the scene, as it were, there'd be some evidence of that. I mean, unless he's some kind of magician. I mean, they do call him Houdini. I mean, just God.
In that regard, what this all is shaping up for is why he's here today. And he's here today because he's cooperating. And he's cooperating because of all of these penalties and potential penalties. So the one that he...
but the possibility of being charged with these aggravating matters may be as much related to the desirability from his point to making a deal.
Wait a minute. I remember hearing about the cadaver dogs a couple days ago. It's me, Josie. Gravely tried to get cadaver dogs in. He wanted them to think there was a body they were looking for at the property. Really? So, like, I don't know, the news media or, onlookers, rubberneckers, if you will. Like for a show, kind of. Ooh, they've got cadaver dogs looking all over the place. Oh, look at that. He must have done it. I think that's what you're implying.
But not this specific deal of assisting the district attorney in Kenosha.
That's true.
It might be a little speculative.
I can just have a couple of questions about it, move on. It's not a centerpiece of my cross-examination.
And it feels like he's either being asked to speculate on what happens in the federal system.
Give me a wing,
And
Dingleberry. Give me a wing.
This is his only venture through the federal system, so he certainly could not testify as an expert about, I mean, it's speculative for him to talk about the federal system.
I'll ask him.
He's even disappointing with his tells.
We already talked about it with his lawyer. I'll ask him. I'll ask him what he knows about it.
He will be asked whether it's common. This was the question that was asked that I objected to. Is it common in the federal system for people to add this particular indictment? And so you would face those consequences.
Yep.
That was not my question. That was not my question.
Well, why don't we do this? Why don't you rephrase your question?
I will do that.
I'm open to some area of inquiry on this line, but there are many considerations that one might make when deciding whether to hasten to deal with the prosecutor. And I don't want to give the jury the impression that it relates to this case unless there's some evidence that it does relate to this case.
I understand. Yeah, I'll tighten it up. No problem.
Ask the jury to come back in, please.
While the jury's back in, thank you so much, Jen RN, for
just let me know if you do.
commenting that at the... crime scene, there were a part of a tooth and some hairs. And we saw that in the pictures. I don't remember the tooth part. But remember mid-May 2020, that was when all the hairdresser shops and, you know, Sally's Beauty was closed. So I would assume someone had said something like it looked like they were cut hairs. And actually, to be honest with you, they didn't look like they were yanked out. You know, when you give someone a haircut, it kind of curls a little bit. And it's, you know, pretty short usually. Just a trim, please. Well, that was the time where even Sally's was closed. We were all watching YouTube videos trying not to make our hair orange or be bald.
Mr. Washington, the superseding indictment, you said you knew what a 924C was?
Correct.
And they didn't charge you with that?
No.
If you went to trial, was it your belief that they could add that charge?
No. I wasn't worried about the gun because, like I said, I wasn't around the gun. I was on the highway.
Okay. So, but you have now a new legal hurdle, this felon in possession charge, right, with the superseding indictment, right?
It came with just a 2-point enhancement or something. They didn't charge me with the gun or something like that, but it's just an enhancement that they gave me for my charges.
Well, are you thinking about the sentencing guidelines or the actual charge?
The guidelines.
Okay. So we'll talk about the guidelines in a minute. Well, maybe we'll talk about them now. What you think is that the
That was not me.
is only an enhancement under the guidelines, which are not mandatory,
It
right?
sounded like my thing, like a game over.
So.
Okay. But you understand that the superseded indictment actually is a substantive criminal charge against you for being a felon in possession of a firearm, right?
Correct.
Right?
We came up with some things, yes.
Okay. Maybe just maybe.
Got to speak into the microphone so everybody can hear it, please.
Like I'm right next to you and I can barely hear you.
Yes.
Okay. So the sentencing guidelines, you understand, are a situation where they have a whole set of criteria to determine what a recommendation to a federal judge will be about your sentence, right?
Correct.
And those are just recommendations, but they're oftentimes followed. Is that your understanding?
No.
No, they're just recommendations.
Correct.
And in your case, there's those are based on having a look at your criminal history, right?
I believe so.
And then, so there's two aspects. One is the criminal history, and the other is the actual offense, right?
Yes.
And so they take the actual offense, and they come up with what they call offense levels, right?
Yes.
And there's a base offense level for the offense itself, right?
Yes.
And in your case, the base offense level is 32, right?
I believe so, yes.
And so what you were talking about is you think it's an enhancement. What you're talking about there is an enhancement for having a firearm in the conduct of this offense, right? And so it bumps it up 2 levels.
Correct.
Okay.
That's what they did.
And so you not only have that, but you also have the actual charge itself, right?
I don't know if I got the charge on her. I thought the charge might have got taken off or something, but either way, I was fighting that charge.
As part of your agreement, yes, right? As part of your agreement, that charge is going to be dropped.
The plea that they offered me, the 10 years, yes.
Okay. So, yeah, that's, so.
I'm sorry, I missed that. What was his answer?
I
His
think
answer to whether it was going to be dropped, that with the offer of 10 years, yes?
I think that's what he said.
Okay.
That's correct. So, and what you're referring
You're
to
witnessing
is the
another child,
mandatory
the stupid smart
minimum
person.
of 10 years for the crime of conspiracy to deliver controlled substances, right?
Right.
And specifically in the indictment, when they allege specific amounts, and I'm looking at page 2 of Defendant's Exhibit 247, the superseding indictment, when they allege 280 grams or more of crack or 5 kilograms or more of cocaine, you understand that those levels are specific statutory levels that kick in the mandatory minimums, right?
Correct.
And so those mandatory minimums are designed, well, the effect is that if you are convicted of that specific offense and you go in front of the judge, and even if the judge wants to give you probation or a minimal sentence, he has no choice but to give you the 10 years, right?
Correct.
And this is the first time that you've been in the federal criminal justice system, right?
Correct.
And you would agree that it's kind of a scary place for you to be, right?
I guess so.
Well, you're kind of worried about the 10 years. Can we?
Solomon just had a really great response. For those of you who are otherwise occupied, perhaps pouring a cocktail or drinking said cocktail. We were talking about, if the jury really understands or cares about all of this, discussion. And Solomon said, I think it is setting up for the appeal, I think. Even if it goes over the jury's head, it is on the court record. Thank you, Solomon, for saying that, because that makes sense. See how wonderful this is? Sharing information, and I responded, "Sir, from your keyboard to God's ears."
We agree on that?
Yes.
And you want to not get the 10 years if you can help it, right?
Yes, I don't feel I deserve 10 years, so yes.
Okay. And so I'm sure you talked about this with your lawyer, but the only way, the exclusive way to not do the 10 years is to cooperate with the government, right?
Correct.
And that's what they call, quote, substantial assistance, right?
Correct.
And the way it works, you tell me if this tracks with your understanding and your discussions with your lawyer, but you agree to provide substantial assistance to the government, and then they decide whether or not it's substantial.
Josie.
Right?
Oh, no.
I believe so.
Spoiler
And then
alert. Don't read
they
the chat.
Decide if it is substantial in their view, that they will file a motion with the court to go below the mandatory minimum.
I'm sorry. I'm gonna unplug all my stuff again, or we're never gonna get through this. This chat is absolutely fantastic. How long ago was this trial? This trial, it's my understanding, concluded. The verdict was read, I think, the beginning of May, but it was in like that March, April, May 2023 timeframe, and it was, I believe, 17 days. Wait, where was that other? Oh, this trial started at the beginning of March this year. Oh, bye Crime Spies. Well, you are Crime Spies. I'm Shannon. This is Crime Spies. We are Crime Spies. Aaron, my fellow suburban Twin Cities friend, have a wonderful evening. Good night. See you soon. Pray for reliable internet on your side of the Twin Cities. Okay. Yeah. Oh, bye, Tootly Pip. Have a wonderful day. Say a prayer for Zachariah Anderson. An appeal followed by an immediate bond, release on bond, until his hopefully drop charges and retrial and sue for millions of dollars. Alrighty.
Minimums, right?
Well, I believe so.
And unless they file that motion, you're going to get the 10 years, right?
I believe so.
So any cooperation you provide, whether it's a debrief in front of agents or testimony in live court, it better be happy. It better make the government happy, or they're not going to file that.
Was March 2nd when Soloman and Jen's baby was born? Is that why we're getting March 2nd as a glorious day? Might have to write it on the calendar.
That motion, right?
I believe so.
Okay. I mean,
So 17
this is
days
a
would be
discussion
3.5
with your lawyer,
weeks.
isn't it?
Well,
Almost a month.
You've inquired about this several times.
Okay.
And I'm a little uncomfortable about your asking him questions about his communications with this attorney.
Oh, okay. Well, I will not do that anymore. I'll just ask him what he understands.
Oh, your birthday twins? Josie's birthday and Solomon's birthday is March 2nd? Are you Aquariuses or is that Aquarius or Aries? Asking March 20. And then March 23rd, Snitchy was released. Good. Baby was born April 18th. So right around the first day of spring. No, that's March. Oh. Pisces. Oh, yeah, that's right. My friend Lynn is a Pisces. Oh, birthday twinning. Oh. Is Arisa's Pisces? You guys crack me up.
Don't move to something else.
Okay, I'm going to mute.
We're talking about
I have to go
there
get something
are
to
some
drink.
privileges in our law that, as a general statement, with some exceptions, communications that you have with your physician or healthcare treatment discussions generally can't be admitted in court without your permission. A conversation you have with a religious figure, like going to confession or some equivalent, depending on your religious beliefs, generally can't be admitted in court. Spousal communications, and that's expanded to other relationships now too. But there are some areas that can't be inquired into in court, including conversations that you have with an attorney who's representing you in a case, generally can't be exposed in court without the waiver by the defendant. And because the attorney is not here to consult with this man, I'm just going to ask that Mr. Birdsall go to another area. And that's what he's going to do.
Yep. Thank you, Judge. This superseding indictment is filed on November 2nd, 2021, right?
Correct.
You are in custody, well, you're in custody by that point. And you're somewhere in some federal holding place, right?
Correct.
Did you immediately come to Kenosha?
After a couple of months, once they transferred me here from down south, yes.
From down south?
That's because I told you I was pulled over on the interstate, so I was in Memphis.
Oh, I see. I didn't realize you were out of state. Okay. So it took a little time for you to get extradited back here?
Correct.
Okay. So when you do come back to Wisconsin, though, you come right to Kenosha, or do you go to one of the other federal holding places?
They brought me here.
To Kenosha?
Correct.
In KCDC?
I went to the county jail first.
Okay. And then you get transferred out to KCDC?
Correct.
All right. And there's a bunch of other federal inmates there too, right?
Correct.
So you're housed, if I understood your direct testimony, about 5 weeks from December 22nd, 2021 to January 31st, 2022, right?
I believe so.
Okay. And that's the period of time when all of the testimony that you stated on direct about what Mr. Anderson said to you and all that, that's when all that supposedly took place, right? Okay. So,
Yes.
so you get moved out on January 31st to some other place inside KCDC?
Yes.
And I believe you said in your statement to officers that it was some sort of classification change?
Yes.
What was the classification change?
Objection irrelevant.
Overall,
I'm a federal inmate, so our level starts at 4. So we initially not supposed to be back there with those guys, but they didn't have the space. And Zach had told me that I was initially going to get moved. Eventually, he was telling me to get my level lowered if I wanted to stay back there because I was a good cellie. But I was new there. I wasn't finna get tickets or go to the hole or mess up myself. So I didn't do nothing about it, and they moved me.
Okay, so you're classification 4. I don't really know how this works. So how high does that go?
I'm not sure. I done heard people have 5s and stuff like that, but a 4, from my understanding, is supposed to be minimum status, something like that.
Okay, so 4 is minimum, but like higher is
Minimum
worse?
as well.
You don't know.
Lower 2s and 1s or 2s and 3s are what they call bad, I guess. I don't know.
Okay, so it gets worse as you go down.
Correct.
Okay. So, but in any event, you move on January 31st to some other location within KCDC.
Yeah, correct.
All right, so then just a week later, your attorney, Mr. Ritchie, gets a letter from Assistant United States Attorney Catherine Helopka Ivory, right? It's what's called a proffer letter. You know that term, right?
Correct.
So sometime in that week is when you must have talked to your lawyer, right?
I
Objection
believe
irrelevant.
so.
When he talked to his lawyer and calls
well,
for
that question's all right. It's,
Now ask him what he said.
yeah, that's all right.
I believe so, yes.
Okay. So you finished with housing with Mr. Anderson. You talk to your lawyer, and 7 days after you leave his cell, you get this proffer letter from the government. Your lawyer gets the proffer letter, right?
I believe so.
Okay. So, and a proffer letter is an assertion by the federal government to say, we understand you want to cooperate. And if you do, we're going to sit down with agents and you got to tell us everything that you did and all the information you want to share, right?
Correct.
And what the letter says, it's I don't know if you ever heard the term transactional immunity. Have you heard that?
No.
Okay, so, but essentially they agree to not use anything you say in that meeting of you giving information against you, right?
Correct.
And it might be commonly known as being king for a day. Did you ever hear that term?
Objection, Judge.
No.
The circumstances of this immunity are irrelevant in a proffer letter. Relevant.
They're directly
Depends.
relevant.
And I don't know. I've never seen it, so I have no idea.
Well, I'm going to show you what's been marked as Defendant's Exhibit 248. Is that the proffer letter that your attorney sent you, or was sent?
I believe
Well, your
so.
question's unclear.
Was this the letter that was sent to your attorney, the proffer letter on February 7th, 2022?
I believe so.
I mean, I'll stipulate that it appears that it's a letter sent to the attorney.
Okay, move to admit the Defendant's 248.
It's got highlighting on it, with or without the highlighting.
With.
Oh, is there a clean copy in existence?
We can print one.
Well, a form of that letter is admitted, unless there's objection.
Okay, one more time.
A form of that letter is admitted unless there's objection.
No objection.
Okay.
Okay. So the letter, first of all, you went over this, or you were given a copy of this?
I believe so.
Okay. And so, and they say, client during the interview, directly against him in any civil or criminal proceedings subject to certain conditions and exceptions. Does that sound right? Does that sound about what you remember?
Objection, and this has been asked and answered. He already asked him, were you offered immunity, and I believe he answered yes.
All right.
Overall,
that was on December 7th, 2022. Not December, February 7th, 2022, right?
Believe so.
4 days later, on February 11th, you sit down with investigators Michael Seeger and Daniel Lagendorf and your lawyer to
Talk to them, yes.
Well, it wasn't just a chance meeting. This was set up by your lawyer and the government, right? Of advancing this cooperation that you were purporting to do is to get you out from underneath those mandatory minimums, right?
Objection, that's been asked and answered. He's already said that that was the purpose.
Yes.
So when you had the opportunity a year ago now, you sat down and you told them about a shooting at GRC Bar in Racine, right?
They asked me about a shooting, yes.
Okay. And that was where you and Mario Johnson and Akeem First were down in Vice Lord's territory, and Akeem First gets shot, right?
He didn't get shot in Vice Lord territory, but the cop said it was Vice Lord's territory, yes.
Okay. But he got shot.
He did.
And you were there to tell them that it was two individuals by the name of Andrian Harlan and Mark Geeter who were driving around and that they did the shooting. One of them did.
They asked me about those gentlemen, yes.
And you said that you think one was driving and one did the shooting because you were there, right?
I was there, yes.
And,
well,
but, oh, sorry.
The question and the answer were not totally congruent. You asked him, was he there and did he do the shooting? And he answered, I was there, yes.
I didn't ask if he did the shooting.
Or, yeah, you're correct. I apologize.
Yeah. So actually you said that Harlan was driving and Geeter got out of the car and shot, right?
I don't think I said he got out of the car and shot, no, because I didn't see that, but...
Okay. Yes. And the reason you didn't see it is because you were across the street urinating.
Correct.
And yet you still sat down with them and told them all about what we just discussed, right?
I sat down and told them what I knew of the incident because they asked me about it, yes.
Okay. And through that entire interview, just days after you leave Mr. Anderson's cell, you don't say a word about this supposed confession to a murder, right?
Well, they didn't come asking me about that. They asked me about a certain situation.
Okay. So, all through 2022, you're in custody at KCDC, right?
Correct.
And all through 2022, your attorney is trying to negotiate with the government about your involvement in that conspiracy, right?
I'm not sure what he was doing in the meantime.
Conspiracy?
The drug conspiracy. Sorry. You're not sure what he was doing?
No.
Okay. Maybe you just didn't have a lot of contact with him?
We had contact, but we wasn't hearing anything. It was just a sitting point for us, really.
But you were looking to cut a deal, though. You didn't really want to go to trial, right?
I wasn't going to go to trial.
I'm sorry?
I wasn't going to go to trial against everything, no.
because it was kind of overwhelming.
Correct.
And you understand that, and you understood that, you know, your only path forward was some sort of a deal, right?
Correct.
And so flash forward to January of this year. I'm going to show you what's marked as Defendant's 250. This is a letter dated January 20th, 2023, addressed from the federal government, U.S. Attorney Bridget Schoenhorn to District Attorney Michael Gravely about your cooperation, right?
I never seen this, but I guess.
About you cooperating in this case. Is that right?
I never seen that.
Judge, he's just testified.
All right.
Yeah.
He's just testified he's never seen it.
Never seen it. All right.
Yeah.
That's fine. So,
Well, don't comment on the answer. He stated he didn't see it,
yep. All right.
and the objection sustained.
But but at some point prior to January 20th, 2023, you communicated to your lawyer that you wanted to come forward about Mr. Anderson, right?
Yes, I did talk to him.
Right?
Well,
I'll
talking
follow
about
up.
conversations with the attorney again.
No, this is what he's saying, not what the attorney's saying.
Yes, and?
Okay. Well, I'll cut the lawyer out. You, sometime in January of this year, so just a few weeks ago, advanced the notion, or had it advanced to the government, that you wanted to cooperate regarding this particular case, right?
Yeah.
And you had just spent the last year wondering what's going on with your case, and so you're thinking testifying in this case might really help that whole negotiation, right?
Yeah, I brought it up to my lawyer and we talked about it, yes.
So that's a yes? You thought participating in this case, cooperating in this case might really help you in your federal case, right?
Objection, asked and answered. He said, I talked with my lawyer, yes. That's an answer.
Well, but there was, it had the taint of it that it was a reference, a conversation with the attorney, and Mr. Birdsall, I think, was trying to clean it up with the follow-up question.
Per the court's instruction, yes.
Yes.
Is that a yes?
Yes, I brought it up to my attorney.
Well, we're
to talk
not
about, yes.
concerned about that.
Forget about your lawyer for a second.
Okay.
You specifically wanted to advance your participation in this trial to help in your federal negotiations, yes?
If it could help, yes.
And you feel like it will help because this is a murder case, right?
I guess so, yes.
So, I'm going to show you what's been marked as Defendant's 252. That's the plea agreement, the proposed plea agreement that you were going to enter into?
Correct.
You have to speak into the
Did you
microphone.
inquire
Yes.
were or are?
Good
Was
point. This is the one you intend to enter into, right?
That's the one that was brung to me, yes.
But the one that you want, correct?
I wouldn't necessarily say that's the one I want, no.
But it's the one you're going to do.
There's a few things I still got to argue in there, so I wouldn't say yes.
Okay. Well, but this is the one that's at issue, though, right?
That's the plea that's on the table right now, yes.
Okay. I would move to admit Defendant's 252.
Any objection?
No.
Received.
So in that agreement, you're facing the conspiracy charge, right?
Correct.
The substantive delivery of crack, right?
Correct.
And the felon in possession, right?
I'm not charged with felony in possession, I don't believe so.
Okay, so I'm going to show you from Defendant's 252. Actually, I'm going to go back.
Counsel, I might have misunderstood your question as well. Are you asking him what he's facing or what the plea agreement
Right now, I'm asking what he's facing, and then I'm going to ask about what he's going to get from the plea
All right,
agreement.
so that's been asked and answered. He's already gone through the superseding indictment and asked whether Mr. Washington recognizes and understands each of the charges. So we've covered that.
So if I could, Judge, specifically, he wasn't sure. Just
Why don't you do this?
Yeah.
Ask him if he's aware of the difference in numbers.
Numbers.
Potential outcome.
Oh, yeah. Well, first I wanted to establish which charges are at play here. And so you weren't sure about the felon in possession. Is that right?
Correct.
Okay, so I'm going to show you page 24 of the superseding indictment, which is Defendant's Exhibit 247.
Again, we've covered this, Judge. We've gone through the superseding indictment. He's gone through each charge. He has walked through each charge with him in the
He's basing the question on witness's answer, which has most recently been given.
Correct. Exhibit 247. This charges on or about October 20th, 2021. Marquand Washington, a.k.a. Munch. That's your street name?
Correction irrelevant what his street name is.
It's part of the indictment.
Well, it's in the indictment.
Which prior to his possession of it have been transported in interstate commerce, the possession of which was therefore in and affecting commerce. Is that right?
Yes.
So that's what you're actually charged with right now as we sit here today, right?
I thought they dropped that, but...
Well, that's what...
Are you saying it's already been dropped or they're proposing to drop it?
I thought the plea arranged for that not
But
to
their
be...
plea hasn't gone through yet.
Right, but the plea that they had came to me with had removed the gun off there because I didn't get caught with a firearm.
The question is, because I asked you, if you recall, whether the plea had actually gone to court with the judge and you had entered your plea, and I think you told me it had not.
Correct.
So you still have a pending charge.
Correct.
And until that time, whatever is charged in that indictment are the charges in the superseding indictment.
Okay.
Are the charges against you.
All right.
And I think what he's trying to do is to compare the potential outcomes between what you're charged with now, which will result in nothing unless the government can prove the case.
Right.
But if you're convicted, it could have a potential outcome. Or if you pleaded guilty, then you won't have any trial, and the judge will sentence you based upon your plea, which will apparently remove the firearms charge.
Okay.
So, but as it stands right now, if you were to go to court and you didn't plead guilty, the judge would have a trial and the jury would decide based upon the charges that are contained.
It's already been admitted as Defendant's 252. This is the plea agreement, right?
Yes.
And so what it says is that the charge is count one that you're going to plead to, right? The conspiracy.
Correct.
That's the one with the 10-year mandatory minimum, right?
Correct.
The other two don't have mandatory minimums, right?
I believe so.
And then if we look on page 3, on paragraph 8 of that exhibit, it says the government agrees to, as part of the plea agreement, the government agrees to move to dismiss the indictment and the remaining counts of the superseding indictment as to this defendant at the time of sentencing. Is that right?
Correct.
And the plea agreement also has a provision for relevant conduct, right?
Yes.
And you understand that relevant conduct in the federal sentencing scheme, when you look at the guidelines, it's all driven by drug weights, right?
Correct.
And so the higher the drug weights, the higher the penalties, or the higher the guideline range, right?
I believe so.
And so in your case, they are, you're agreeing when you sign this, if you sign it, that the defendant is responsible for at least 3,000 kilograms, but less than 10,000 kilograms of converted drug weight. Is that right?
Yes.
And what they base that on is multiple different drugs, and they have a formula that comes up with that, right?
I believe so.
So, but specifically 30 kilograms of cocaine and 400 pounds of marijuana as part of your taking responsibility in the actual case, in the plea agreement, right?
Yeah, that's what they want me to take responsibility for.
Right. And they dropped all that crack stuff, right, as part of relevant conduct, right?
Right.
And your base offense level, you're agreeing, is 32 under the guidelines, right?
Correct.
So, but if we look on page 6 of this exhibit, just to be clear, 252, in the guidelines, you're a career offender. Is that right?
I qualify as one, they say yes.
Okay. And a career offender is somebody that,
Again, why he qualifies as a career offender is not relevant to whether he's honest or not. What he's charged with.
I'm not talking about why he qualifies. I'm talking about the effect of being a career offender.
Well, no, your question actually did.
I can rephrase. No
Go
problem.
ahead.
So, but if you sign this, you agree that you understand that the probation department, the United States Probation Office, they will do a guidelines calculation, right?
Correct.
And they've already told you that you're a career offender based on your criminal history, right?
Correct.
And so are you familiar with the guideline chart?
I've seen it, yes.
Okay. So I'm going to ask you if that's what we're talking about?
Yes.
Okay. And I'm going to move to admit, I believe, defendant's 253, which is the guidelines chart.
Is there objection?
No.
Received.
All right, so I'm putting it up on the chart here. So here we have two axes. On the left is the offense level, right?
Counsel, I'm going to approach just close enough so I can see this because the writing's.
Yeah, it is.
I apologize for approaching.
That's all right.
I didn't hear your answer, I'm sorry.
Yes.
Okay, so this is the offense level, and this is the criminal history category, right?
Yes.
And it's those two numbers that eventually find their way into a guideline range of potential imprisonment, right?
Yes.
And in your case, because you're a career offender, you're automatically in category 6. Is that right?
Correct.
Okay, maybe pull it,
Correct.
Yep. And under the plea agreement, you are looking at a base offense level of 32, right?
Correct.
Correct. Except because the offense that you're going to plead guilty to has a maximum of life, your actual offense level is 37, right?
No.
Well, it's one of those, if you're 32 in category 6, your potential imprisonment is 210 months to 262 months, correct?
Correct.
And that's your understanding?
Correct.
And so that is different than the mandatory minimums, right?
Correct.
The mandatory minimum would be 120 months, right?
Correct.
But you're potentially facing up to 262 as a suggestion to the judge per the United States Sentencing Commission, right?
Those are the guidelines, yes. But if I accept my plea, it's 3 points knocked down as well, so.
Right. Right. If you accept your plea, they take you down 3 points. So let's just do the math here. And we'll take you down to level 29, and that'll be 151 to 188.
Correct.
Is that your understanding?
Yes.
Okay. And by when we say coming down 3, that's called acceptance of responsibility, right?
Correct.
And that also is a motion by the government to take that down 3 levels, right?
Correct.
And so on 2 levels, in 2 categories, you're depending on the government being pleased with your testimony here today. Is that fair?
Yeah, I guess so, yeah.
Okay. Because on 1 level, you want to bring down your offense level for the guideline range, right?
Yeah.
And on another, and bigger and more important, is you want them to make that motion to Judge Edelman to get you under the mandatory minimums, right?
Yes.
Because, as you said, you just don't deserve it, right?
Correct.
Before you sat down with the government, they had advised, well, you knew that they knew about certain things you had done both before you were arrested and while you were in jail in KCDC, right?
What do you mean while I was?
Well, specifically that you and another person had threatened a confidential informant during the investigation of a case against you in 2020, right?
No. That's the same thing you asked me about earlier when you said that we was riding around with guns. That's
Okay.
what they mentioned.
Okay.
Correct.
So they're saying you threatened, and you're saying you didn't.
Correct.
Okay. So, and then in 2022, while you were at KCDC, they discovered you had a USB drive in your cell, right?
Correct.
Something like this, right?
Correct.
And that contained the discovery for your case, right?
Yes.
And there was the judge had signed a protective order specifically barring the copying and sending out of the discovery materials, right?
I never seen that, but
Okay. Well, they discovered you had it, and they confiscated it, right?
They came for something else, some pornography or something somebody else had going on, and they took it, and I haven't received it back, but I have been asking for it back because it is mine, and I can't have it, so.
Well, you can't have it because a federal judge entered an order saying you can't have it.
Well, objection.
I never received that order.
Objection. He has already testified. He doesn't know that.
He didn't let me finish my question either.
Well, but let's go back even a step back more. The discovery that you're referring to is the discovery in the federal court case,
That's
not
correct.
the case here.
That's correct.
All right. And
be
so
clear
why
about
don't you start over with a question?
Okay. So the USB drive you had in your cell was for your conspiracy case, the federal conspiracy case, right?
Correct.
And you're saying you didn't know anything about the protective order.
Never got it.
Okay. You never, not to talk about, like you were never advised by anybody that you weren't supposed to have this?
Lawyer never mentioned nothing like that to me.
Okay, so because there's federal inmates at KCDC, they make arrangements, the federal government makes arrangements for defendants to have access to the discovery, right, in a separate room, right?
Correct.
And so how did you manage to get a USB with all of your discovery despite the prohibition?
We can buy them, but I bought an extra one from Mr. Anderson.
So you bought a USB drive and you went into the separate room to look at your discovery and you made a copy of it?
Correct.
Okay. So now that's been confiscated from you, right?
Correct.
All right. So in January, you had an epiphany about talking about Mr. Anderson's case with, so that you can get help on your federal case, right? We've established that.
Objection.
Right? I'm sorry. I'd like to finish my question, if you don't mind.
Well,
I'd like to finish my question, Judge.
I'm objecting to the term epiphany,
Yeah.
which was the beginning of the question. It's argumentative.
Well, it's a word that's frequently misused. So I don't actually know what he's looking for. Epiphany means manifestation. And so I don't know. That's kind of a...
It's very peripheral.
You must have one of the brainiacs because that only they studied Greek when I was in school.
Okay.
Start your question over.
All right. So in January, you decide you're going to advance the ball on Mr. Anderson's case to help your federal case. We've established that, right?
Yes.
Okay. So then on January 17th of 2023, just, I don't know, 3 weeks ago or so, you sit down with some police officers and the district attorney, right?
Correct.
Specifically, you were sitting down with all of the people at this table, right?
Correct.
Detective Carrera, District Attorney Jessika, kept on your name, Krizarek, and District Attorney Michael Gravely, right?
Correct.
Those 3 people at this table.
Correct.
And also, it was Warren Anschutz. You remember that name? There's another person there?
I believe so. I don't remember the name, but
Was your lawyer there?
no.
He was not there for this interview.
No.
Okay. But you sat down at Kenosha County Jail, right?
Yes.
And you met with these 3 individuals for about an hour and a half?
I didn't count the time, but
Sound about right?
I spoke with him, yeah.
Okay. And as you were being asked questions, who was doing the main questioning? Mr. Gravely?
Correct.
Okay. Was that like exclusively throughout the interview, or did the others kind of like chime in once in a while?
Everybody spoke up, yes.
But it was mainly Mr. Gravely?
Yes.
Okay. And he made it clear to you that he was very interested in having you come here, right?
He wanted to hear what I had to say, yes.
And that after you testify, he's going to report back to the United States Attorney about how well you did, right?
My lawyers did. He probably would talk to him.
Nope.
Yes. He didn't really, I didn't ask him that.
Okay. But that's what you're hoping for.
Objection, we've covered this area. What he's hoping for, ask and answer.
Overall.
Yes?
Yes.
All in service of getting you out of the mandatory minimums and possibly the 262 months that in theory you face, right?
Whatever it would help with, yes.
In fact, the charge against you actually has a maximum of life, right?
If I go to trial, yes.
Well, whether or not you go to trial, it's still a maximum of life, potentially, right?
Correct.
And so the guidelines say one thing, the mandatory minimums say another, and you're trying to get down to something where you can get back on the street, right?
Yes.
Just one moment, Judge.
Are we having fun yet? I gotta clip that thing with the judge in the orange. That's almost as funny as the sus bus. Although I was gonna use like either Curb Your Enthusiasm, but it doesn't quite fit. So I'm trying to think of a sound that would be good with that. Any suggestions? I know, but like, what would be a really good sound that would go with that? That's what I was trying to think of. I'll come up with something. I've already spoiled the Pac-Man. Pac-Man got eaten by a ghost
Ms. Washington, when you
sound for
the
you.
drive, this was actually.
I was
using
going to
this as
use
an
that
example,
for
but when you got the drive when you're in your cell,
Dingleberry.
you got that from Zach, right?
Correct.
And in fact, you stole it from Zach. No?
No.
Okay. In any event, there was already material on it, right?
Zach removed the material from it and sold it to me, yes.
Okay. So if the government who seized it found that Zach's discovery was on it, in addition to your discovery, you'd be surprised to hear that.
Yes, I will be.
Okay. I think I just need to move in.
I also sent money to Zachariah.
I just need to move in Exhibit 250. Proper letter, or the letter to Mr. Graven.
Is there objection?
No, no objection.
Received.
And
Was that a prompt for Dingleberry to object
Thank
to
you.
something?
Redirect.
Mr. Washington, is it your understanding that if you lie in a courtroom like this, your entire grievance is blown?
Yes.
Is it your understanding that if you give false information to the DA's office or any other place, your entire grievance is blown?
Yes.
Pardon me? Well, his credibility is certainly an issue. Overruled.
So if you tell a lie here, or if you tell a lie to law enforcement in a meeting, et cetera, that all of those consequences that were talked about by the defense are things you're going to have to face. Isn't that right?
Correct.
Nothing else.
Any question?
Ooh, wow from Zelda.
All right, let's break at this
Thank
point.
you, Solomon.
Please don't talk about the case during the break. Read, watch, or listen to any account of the trial. Informational. We'll be breaking for the day around 2:30 today. Okay.
I
any
made
questions,
an
anybody?
executive decision to bump
And
it
I'll
up
get
to
you more information about
1.25.
tomorrow,
And then
as
I
soon as I get it.
kicked myself for not thinking of that sooner. So this is the point where we pause for a moment and reflect on the fact that Zachariah Anderson has been incarcerated for 1,319 days. So far, we are at almost the end of day 8, so not quite halfway through. And I don't know about you watching, but I'm not seeing how this case even got brought to trial.
All right. Good afternoon, folks, and
I'll slow
let's
it
continue
down.
with the state's case. What's our timeout?
So I had to pick up all the pistachio shells. That took quite a while. Then I went
Stand and
out.
swear the testimony you are about to
Oh,
give this
he
matter will be the
remembered to
truth, the
swear
whole
in
truth,
this
and nothing but the
witness.
truth, so help you God. Would you have a
I went out and Lily looks at me. She's cleaning her room, watching in her room.
Kayla
She's
Petty,
like, Mom, your
PETTY.
chat is fantastic.
Petty, did you know somebody named Rosalio Gutierrez Jr.?
Yes.
And how
Something
did you
just
know Mr.
spelled down.
Gutierrez?
He was the father of my daughter.
Oops, sorry.
And from what year to what year were you guys in a relationship?
I would say the end of 2007 till
So this is one of
2000.
the victims'
Oh my God,
baby mamas?
16-ish.
Correct.
And what year was your daughter born?
2012.
And
So I have
back
3 more
in the
witnesses.
time frame of May of 2020, was Rosalio involved in your daughter's life?
Yes.
Did he have her for some weekends of a month?
Every other weekend.
Did he take interest in her activities?
Yes.
What kind of activities was she involved in that he took interest in?
Dance and gymnastics, cheer.
Oh, no. Things were going so well. Now what's happening? Mark, are you watching? Time is it? 9:30. This is why I don't understand. I don't know if you can see this for those of you who are tech people, but see down here it says I'm live excellent. And then Mark. Where's my mouse now? Oh, my mouse is. And then here on the bottom, see, it's still going. Excellent. We have had some dropped frames. Still pretty good considering the duration. So I don't really know why this continues. It's not like this number is. So Mark, if you're watching, can you maybe, find my digits tomorrow? And help me fix this? No, I gotta find... I don't get it. Sigh. Does anybody else have this problem with really long live streams? I mean, this one's already been cut off once. Let me try one more thing. Well, if you can still hear me, I'm still getting the spins. Let me see if I can go into Rumble. If I can't get into Rumble, I don't understand what this is. The light is blue. It's not red. All right, so if you can hear me right now, I apologize again for some weird... Are you sure it's your browser? I changed the browser. Well, I deleted Brave Browser because I thought maybe, it's just kind of a coincidence. Okay, this is weird because if my internet was down, why does Rumble come up? Oops, wait. Non-responsive. Oops. There's 21 people watching on Rumble. Hello, all of you watching on Rumble. I'm not sure what's happening, but I'm going to try one more time here with the YouTubes. I kind of like to get through this day. I know it's getting late. I appreciate you. Let's see if my puzzled look pops up here. Just blue. See, it's working on Rumble. All right, so if you can hear me right now. So I'm still connected. Rumble is working, but YouTube isn't coming up. What is that? Okay, let's see here. Hold on. Let's try to finish this. Oh, FFS. Now I gotta find my iPad. Where did I put it? Okay, I'm not digging this two-step verification all the time. I think we're back, people. Give me another moment. I'm sorry. Go grab a snack or refill your cocktail. Or just give up for today and come back later. I already did that. Okay, so Mark, if you're watching right now, how in the world does Rumble work? And OBS is working, the light is blue, and I can't get into YouTube. There, I think I'm finally in. FFS. I'm sorry, people. I mean, if I can get into Rumble, but not YouTube, that couldn't be my, router, I wouldn't think. See, look, it says I'm not connected. All right, I'm going to give it another minute. Or quit. I think I'm going to quit. I don't want to keep you waiting. Tomorrow's Friday, and Nick's... Oh, here, see? It's back. See, I'm telling you, people, over on Rumble, the true crime community is growing. Just so you're aware. Yet YouTube continues to screw with my stuff here.
Is it your understanding that
Okay,
if
at
you
least
give
I know
false
kind of where we
information
are
to
here.
demolition for
About
15 seconds. Just tell me where the testimony you are about to give.
Back in the time for that weekend.
Yes.
And so what was the plan in terms of him returning your daughter to you, if you remember?
He was to return her that evening, Sunday.
Okay, I'm sorry now.
Yes.
I just want to direct your attention to May 17th of 2020. That would have been a Sunday. Did Mr. Gutierrez have your daughter or placement of your daughter for that weekend?
Yes.
And so what was the plan in terms of him returning your daughter to you, if you remember?
He was to return her that evening, Sunday.
And do you recall if he did that?
Yes.
And back in May of 2020, what city or town were you living in at that point?
Twin Lakes.
So that's some distance away from Kenosha, the city of Kenosha?
Yes.
If you had to estimate, how long would you estimate it takes to get from Twin Lakes to the city of Kenosha?
I would say about 30 minutes, 30 to 40 minutes.
And so on May 17th, what do you remember about Mr. Gutierrez coming to drop off your daughter that night?
He showed up around 8:20. I remember that specifically because he was supposed to come a little later, but he did arrive earlier. Dropped her off, stayed not very long before leaving.
And was that the last time you ever saw Mr. Gutierrez Jr.?
Yes.
Since May 17th at roughly 8:20, 8:25 p.m., have you ever heard from him again?
No.
Has there been any reach outs by him to your daughter?
I think it's
No.
been established something did happen.
I'm going to show you
him.
a couple of pictures, so I'm going to direct your attention to the screen. This first one is on State's Exhibit 1, number 251, as soon as it pops up. So in this picture, on the left-hand side, can you see a pink note on a pillow?
Yes.
Irrelevance.
Do you want me to answer that, Judge? Because I can.
Is the judge
The
sleeping?
next picture. I'm now going to show you picture number
Is that the part where he's
252.
caught watching
Do you see
someone's
that
live
close-up
stream?
of that note?
I do.
And do you recognize who wrote that note?
Yes.
And who is that?
My daughter.
Your Honor, we already had a ruling on this issue. The defense had objected to this, including,
It's sustained an objection.
yes, you did.
Take it down off the screen.
Could we have a moment outside the presence of the jury? I can approach in a sidebar, Judge. I don't mind doing that.
Court of Appeals doesn't like those.
Oh. I just had an idea. My idea is there's like a test that you can run on OBS, and I haven't run one in a while. You know, kind of tinkers with like the frames per second and the kilobytes per second. Wondering if I should do that tomorrow before. Well, actually, so Nick's live stream tomorrow, 4 p.m. Eastern Standard Time, which is how Encyclopedia Crown's clock works. That's the only time it reads. So that's 3 p.m. my time. So should we maybe take tomorrow off so that we can all focus and spend the morning social media sharing the live stream information? Question mark.
The handwriting on that note, do you know who wrote that note?
Yes.
And who wrote that note?
My daughter.
The 7th.
Well, at least we haven't heard that creepy guy whispering into the microphone how much he loves this. That was weird yesterday.
I have no further questions. Thank you.
That was fast.
Good afternoon. On May 17th, 2020, you, when Mr. Gutierrez was at your apartment or home, I don't know, you have a house, not really relevant, but were you able to observe what he was wearing?
I was.
And do you remember today what he was wearing on that date?
I do.
Can you please tell the jury?
Tennis shoes, a pair of athletic sweatpants. I do not remember his top.
Was he wearing a hat?
He was wearing a hat.
And was he wearing his glasses?
He was.
No further questions.
I have nothing based on that. Thank you.
Well, that was fast. This might be a good time to remind everyone, this man here at the defense table, he's been incarcerated for 1,319 days.
Are you ready for the next witness, Judge?
Yes.
All right.
There are
case call
2 more
Susan Brown,
witnesses, and then you will be dismissed from class. Law School 101. How not to move forward on a criminal trial. And part B, how not to let your courtroom go wild.
Raise your right hand, please. Do you solemnly swear
Part
the
3,
testimony you're about to give in this matter
how not to be a
will be the truth, the
dingleberry
whole truth, and
attorney.
nothing but the truth, so help you God? Yes. Please be seated.
Ma'am, I'm going to ask that you speak into the microphone just so that we can have the maximum
okay, we got it.
sound. This is a tough room to hear in. Can you do that for me?
Okay.
Thank you.
Maybe it's because
Can
you've blown out
state
your
first and
eardrums
your
because you
last name
talk so
and spell
loud
your
all
last
the
name for the
time.
record.
I'm Susan Brown Williamson. My last name is BROWN-Williamson.
So this is
so how do
Zach's
we spell
employer.
Williamson?
This is
Just
going to be interesting.
WILLIAMSON.
Thank you. Ma'am, back during the time period of May 17th, 2020, did you own a residence in the municipality town of Belgium, Wisconsin?
Yes.
And was that at 309 Cedar Beach Road?
Do they have chocolate there instead of cheese?
Was it in May of 2020, were you trying to do some renovation or work on that property?
Yes.
Did you hire someone to help you with the demolition part of your renovations?
I did.
And is anyone that you hired to do some of the demolition for that property here in the courtroom today?
Yes.
Okay. Could you point out where the person is who was hired to do some of that demolition and just indicate what that person is wearing today?
He's wearing a grayish shirt and a suit and tie.
Point to that individual as well? Okay. Thank you, Judge. I'd ask that the record reflect that Ms. Brown Williamson has identified the defendant. Ms. Brown Williamson, in general, what was the work that the defendant was being asked to perform for you?
He was doing demo on an old house that preparing for a remodel.
And so what rooms of the house was the defendant involved in demolitioning for you or doing demo for? What rooms of the house? The whole house or just specific rooms?
The kitchen and 2 bathrooms.
Okay. And how was, to the extent that you know, how was the defendant accomplishing that? Was he using a vehicle, or how was he moving things out of that house for you?
So he was demoing and then bagging things up and using his vehicle and my trailer to haul stuff away.
And was your trailer something that could be pulled with a vehicle?
Oh, goody, more spins. This makes no sense to me. I can see my face on my own YouTube channel talking. Yeah, we get the spins. For those of you who live stream, can you tell me what this is? Let's see what's happening on Rumble. Maybe, well, Gordon Freeman 81, thank you so much for following me on Rumble. Stray Cats Way, thank you also for following me on Rumble. Let's see what's happening over here. That's just weird. That's just weird to me. I was going to say, why in the world does... Oh, you know what? That's a problem I was having before too. Like 1 minute would be HD and the next minute it'd be 360. I was going to say if Vielhammer is watching now or in the future, you may consider uploading your videos onto Rumble. Well, although there's a video I posted. Yeah, see, look at this. Check this out. See, look. So we're watching the Rumble live stream with the spins, and I'm talking. So it's not Rumble. Now what is it doing? I think now it's confused. Now it's going to probably... Oh, I don't know. Maybe I don't know what I'm talking about. People are leaving over there, too. Well, I think I'm going to end. This is just silliness. Still better than a lot of channels. I would entertain you with another story. Call it the tech guy. You mean Mark? Mark, if you're watching, well, for starters, why aren't you on vacation this week? I thought you bank it all for the end of the week. Number one. Number two. La Kong Express says my YouTube has been changing quality to the past week. Wait a minute. So my YouTube channel seems to be working because I'm watching it on my iPad. So why is... Well, like I said, there is a setting in OBS that you can test it. And I actually just went down because, well, some people were suggesting maybe it was trying to shoot out too fast. The quality was. I don't know. So then I dummied it down. Maybe that was a mistake. You can test it. All right, people. Well, I think, yeah, it's not your live stream. It's just a video you're streaming. You mean Vielhammer's video? So you're saying time for Nuka Kiddos. What does that mean, Nuka? Kiddos? Well, and another thing with Rumble, if you do ever go live stream on Rumble, they upload in HD, but when you're a watcher, you have to switch the gear because it automatically defaults to 1 megabyte per second. I think. 1.2 megabytes per second, which is 360. You have to switch it to 4.5, and then it'll come through. Usually. Yeah, see, that makes no sense. Well, I would enchant you with more stories. Your broadcast. Should I back it up? No. Let's see. See, it says I'm offline. I'm not offline. How can I be offline if it's going through? This is madness. Alrighty. So here's what I think we should do. I think we should say a prayer for Zachariah Anderson. And I mean, I'm watching my own live stream with the spin on the other side. I think we should say a prayer. We should take this opportunity now. Just say a prayer to the Anderson family and hope that the new year brings an appeal followed by a simultaneous release on bond and then an acquittal. I think that's how it works in legal terms. If I'm wrong, I'm sure Encyclopedia Crown will correct me. Tomorrow, what I could do, since Nick is starting at 4 p.m. Eastern Standard Time, I could, if you would like, do a very short one before that. So just let me know. I am on Discord now, although I'm trying to remember how to use it. We used that back during the mass censorship of 2020. Let me tell you, it was a slaughter. Mastered all of these fine videos that we are watching. And the Wrongful Podcast crew. Fine ladies indeed. We still have to figure out which categories we can vote for Podcast of the Year, Female Narrator, and True Crime category, as well as hopefully a couple other ones, you know, to kind of boost up the odds. Okay, now I'm just going to quit. And, let's see, who else is down there, underneath there? Then I have, the free ZachariahAnderson.org website with all kinds of information on it, including merch and the Give, Send, Go, which for those of you on Rumble, you'll be happy to know that they're using Give, Send, Go as their platform that they choose to use. What else is down here? Oh, I can cheat and look. Then, if you missed it a couple weeks ago, The Broken Baker had an interview with Soloman Anderson. That's what got me hooked. I was just sucked in. I still feel like a heel for not jumping on the bandwagon a little earlier. And then we've got Making Law Simple, Denny Motion, video link, and closing arguments analysis for the Zachariah Anderson trial, which I am not going to watch until after we get there. Then we've got Steve Gosney interview with Tiffany Roy. We have Law King Kong. He was christened on the Serendipitous Christmas Kismet Marathon christening. Link to his channel with his 4 excellent videos. Stray the Warrior Princess, thank you so much for your assistance. I hope you enjoy sitting back and relaxing. I do need to have Botrix do your work. Well, it's not your work. You're just helping for fun. I don't expect anything other than to see your beautiful name in the chat. Warrior Princess. You might consider changing your name. Okay, then there's the link to the upcoming fundraiser live stream tomorrow on Nick's channel. And then recommendations to Subscribe to Crime Analysis 101 with Detective John. He's been in the chat several times. I was a guest over the weekend on his show. Very honored. Salvador Dali. You know how much I love Sal. Everybody, they're hard on him. And hashtag I stand with Sal. And Kristine, there's a link to her channel. And then there's a bunch of just, garbage. All right. Well, I hope you have a beautiful, wonderful day. And I guess that is all for now. So, in closing, again, prayer for the Zachariah Anderson family. Pray for his comfort during his incarceration, which will frankly take a miracle, but it is kind of a Christmas miracle. We are all together on this journey. Don't forget to get your bananas. I might have to do a short explanation of the banana smash that you can share with people. Hopefully we can get that trending somewhere. Hashtag free Zachariah Anderson on your banana. Preferably one that's yellow, so like it's legible when you scratch it in, yet ripe enough that when you stomp on it at the stroke of midnight, it's, easier. All right. Have a beautiful, wonderful day, and we will see you soon.